Call the meeting to order. Good morning, everyone. This is Chairman Kirkbride. We're streaming audio again today. Day 2 of the Judiciary Committee meetings of the Jonah Building in Cheyenne. Yeah, thank you. Have a few introductory comments about our schedule, and then we'll get going. We have a couple of new judges and justices who've joined us. Chief Justice Davis, thank you for being here. And Judge Christensen, we never acknowledged you yesterday. You sat in with us, and we'll hear from you in a few minutes. So thank you for being here. I was reminded to remind you to press the button until it turns red on the microphone on the desk when you come up to speak. There is a little red dot that'll appear if everything is working as it should. So make sure that's on since we are being streamed. I want to give you a word about our schedule since it's maybe a little unconventional. But what we're looking to do today is hear from the rest of the panelists. There's about 5 more people listed that will allow for time to speak, beginning with Mr. Odekoven. Then we'll go to a time of public comment. Then we're going to hear from the Council of State Governments people, Mr. Pelka and his associates. In theory, that maybe gets us to 11, and we could start working bills, but certainly we have to be done with that by lunchtime. And then I'm suggesting we take an abbreviated lunch from 12 to 1, and then we'll meet and try and be out of here by 4. We have 10 of us have to be in Casper tonight. We got to beat the snowstorm up there to get to the Republican caucus. Now, I know Representative Pelkey would tell us if we were smart, we'd just go to Rock Springs on Sunday and avoid the problem.
Doors always open.
Yes, but that's not apt to happen so much. We'd be honorary members.
Well, we do have an open caucus, so if you decide you want to make the switch, you're always welcome.
Thank you for that. I did want to recognize, well, it's early in the day and we're all still bright and sitting upright in our chairs. Say thanks just to all of you who followed us these last 2 years. We've had wonderful support from the Judiciary, of folks here at every meeting. We've appreciated that. But there's lots of you for whom this is sort of your home committee, and you've sat these long hours with us and helped us work the bills and provided good input. Thank you for that. I also wanted to acknowledge a couple of our committee members serving their last day on the Judiciary Committee, Representative Winters and Co-Chairman Christensen, for sure. And Representative Winters, you were on this all 6 years. Is that right? Oh, you were on 4 of your 6. And Mr. Co-Chairman, how many years were you chairman?
5 years chairman and 8 years on the
committee. Yeah. So thank you for what you did here, and we acknowledge what you did this summer and your brave attempt at reaching for a higher ring, and you presented yourselves well. We're proud of you in that.
Will you give him a hand, Mr. Chairman?
Let's do. And some of the rest of us may or may not be here next year either, but we'll know more about that in the next couple of days. But it's been good, and hopefully we've done productive work and have another day in us to tie some of these things up. So having said all that as an introduction, let's get back to our panelists. Mr. Odekoven, don't forget the red light, and welcome.
Thank you, Mr. Chairman. Byron Odekoven, representing the Wyoming Association of Sheriffs and Chiefs of Police. I'm not sure if it's good or bad to be first on the list for this morning, but hopefully I've had enough coffee and it doesn't kick in too badly over the course of the start. I appreciate the committee's efforts over the last couple of years working on the major issue of justice reform from the standpoint, and I sense that the direction is we have a brewing issue at the pen. In all likelihood, we'll need to add more beds if we do simply nothing, because criminals seem to be continuing to be criminals. And that is one of the underlying points that we need to remember, is that the criminal behavior will still continue to be criminal behavior. It's how we choose to deal with it between now and the idea that they would be arriving at the pen. With that, we've talked about, and it's been my usual open, if you will, every time I present before you, that I'm hoping that the process brings early intervention, early options, early treatment, early counseling, early interventions to ensure folks are successful at leading or changing their behavior to become a law-abiding citizen and stay out of the criminal justice system. So today we have a series of bills culminating after the Council of State Governments has presented a lot of data. And I appreciate their data mining, looking at the specific points in Wyoming, looking at the numbers of felons, the recidivism rate, the options that we have currently, the options that we may need, where some of the shortfalls are, and how best, from their perspective, to offer suggestions. A couple of the takeaways that I had after the June meeting in Laramie is that there is a need for early intervention. There's a need for additional sanctions early to help slow the stream or slow the flow to the state pen immediately if that person can receive the proper counseling, proper treatment, and a proper intervention that turns their life around, that ensures that they lead a law-abiding life, that they choose not to return to a life of crime and continue their criminal activities, which ultimately ends up leaving them in jail. We heard a number of stories from the prosecutors, from the judges, and from citizens of the current system in which folks are out either on unsupervised probation, which is where they merely tell the judge, yes, Your Honor, I realize I've probably committed this crime, and I may or may not have already pled guilty to this crime, but I'm here to tell you today that I'm going to lead a law-abiding life, and I won't ever do these kinds of activities again, I promise, and away they go. Nobody checks on them until they all of a sudden pop up on another criminal enterprise, and we look at their list of things they weren't supposed to do that they agreed and swore that they wouldn't ever do again, only to look at that list and go, yeah, but you did most of these things. That's why you're here. And thus we end up back in front of the judge who's equally frustrated going, now what do I do? And the series of Justice Reinvestment, I hope, looks at answering that question of now what do I do? The second scenario is probation. A number of people are placed on probation, placed on parole, and looking at supervision in some format to, again, ensure that they have a law-abiding life. The problem that we looked at, or that I think part of the CSG data pointed out, is that is for the upper end of folks, not necessarily for the misdemeanors. And it's been the Department of Corrections position. They'd like to get out of the misdemeanor probation supervision altogether. When in fact, part of the data points out that if we intervene with these people early, we are more likely to make a difference in the long run. And I would offer that more probation early may lead to less time for those folks in the pen. So it's a cost. And we've talked about it at the last meeting, and I sense we'll talk about it a little more today. It's a cost-benefit analysis. Do we put more money in early intervention, treatment, counseling, probation, or do we wait and spend more money on beds at the pen? One of the bills before us looks at answering that from the standpoint of we'll just cut back on the amount of time that they're on probation or parole and shorten that time window by several months, from 5 years to roughly 3.5 years. What I'm unclear is what additional sanctions, opportunities, interventions, and treatments will be before these folks to ensure that that length of time they're successful. Because the current data, or the data mining that CSG provided, pointed out to nearly 20% of the folks recidivate in year 4 and 5. I think it's 9% in year 4, and I forget the actual number for year 5, but it's a lesser number, little less than 20% in the long run. So if we shorten the time of probation and parole down without doing any additional interventions, what are we going to do with the trend and probability that nearly 20% of the people will reoffend in year 4 and 5, but they won't be on probation or parole. So that new offense will be a crime. That new offense will be a charge. That new offense will be a jury trial. That new offense will be a pre-sentence investigation. That new offense will be additional supervision in some light, where currently if they reoffend in year 4 or 5, it's generally a hearing, generally a revocation, less expense. So is there truly savings on one hand versus the long term? I'm not sure. You should be sure, or have some assurances. So that is of concern. What are we going to do in year 4 and 5, so to speak, if they aren't on probation and parole? Or what did we do in year 3.5, or the first 3.5 years, to ensure that they are not part of that 20% in year 4 and 5, would be my point. When it comes to House Bill 230, or I should say, sorry, Freudian slip, Draft 230, it looks at probation incentives and sanctions, and there's several paragraphs in there with shall nots or shalls. And one of the challenges I had looking through the bill, and I wondered, and I already have asked both the prosecutors and the judges, does this bill flow with current practice and law? Will it make a difference in current practice and law in the shalls and the shall nots? Does it actually flow? Does the sanction come in at the right time? Does the non-sanction come in at the right time? Does that quick dip, I think is the term we've been using for the last several years, that incarceration come in at the right time? And is it properly funded? Without the funding to go with this bill, or the funding is not connected to this bill at this point. So I'm not sure where we are with the funding. But there's several pieces of this, and I'll go through several of the points that require additional funding. And I'm sensitive to the idea that if you don't fund it, I'm not too sure we're for it, because many of it involves being placed in the county jail or additional burdens on the cities, towns, and counties from the standpoint of providing additional services without funding. So let me run through a couple of quick points with that as a backdrop as I work through parts of the bill with a couple of questions. And I wished I had the answers. I'm not sure that I do, but I want to make sure that over the course of the discussion, we seek those answers for clarity to the bill. The first one that comes to mind starts on page 5 with authorizing sanctions under 713-1802, switches to page 6, and starts at line 5. A sanction of time served in custody between arrest and hearing, between arrest and disposition of alleged violation of the hearing, is not held, and goes through some of those terms. Part of what we passed in June in Laramie addresses part of that, which I think was good, and that is the whole premise of what do we do with folks between the time of arrest, they're innocent, they're out pending trial, but the judge looks at them and says, lead a law-abiding life. And you looked at 24/7, you looked at some additional sanctions that from the defense and prosecution standpoint, they get to have their folks come to jail with some assurance that they haven't indulged in alcohol, that they're leading more of a law-abiding life prior to coming back to court. So I think that starts there, but I question if that's where that fits, that sanction and where does that fit with our current admonishments from the court as you work through that continuing list? I didn't track on line 13, 15 additional days in jail. I'm not sure where that quite comes in, and would want to hear part of that. Again, that would be a cost back to the county on this 15 days in jail. Over to page 7, starting on line 8, if I read this correctly, we now start a period of time for 90 days in a consenting Wyoming jail, coupled with substance abuse treatment contracted with and paid for by the department. I think that starts our discussion of that early intervention and that treatment for some of those folks. But again, the confinement for 90 days in the county jail needs to be funded. Now, we have a funding in here at some point where we talk about that a little bit, but it's at a much lesser rate than the cost. Because if we're switching part of the discussion, currently, the courts for misdemeanors sentence people to the county jail or for periods of less than a year. Generally, they don't sentence felons to the county jail for any period of time. There's a sanction that can be had. There's some time in jail, so to speak. But generally, sentencing of a felon, the definition of a felony is by being held in the state pen for 1 year or more. Back to the counties, need to kind of flesh that out and make sure that flows. And of course, then the funding that may need to come with that. Otherwise, you're looking at Justice Reinvestment, asking the counties to start picking up felony incarceration time and money. Is that what we're doing? At the bottom of page 7, and again, I asked the judge, or asked the judges to weigh in on the phrase that require a sanction shall utilize incentives. I'm not quite sure what a sanction at this point is. We talk about sanctions, but I'm not sure where that quite fits and whether it flows in the current discussion of sanctions. On to page 9, if you will, line 19, seems to be a contradiction with 20 and kind of our good time discussion. So now we're looking at custodial sanctions. I presume part of those will be in the county jail, but again, I haven't tracked how it quite flows. And the pen, and 19 says, all time in custody related to compliance violation shall be credited toward the probation, for the defendant's probation, parole, custodial, or conditional release sentence. So they violate a determined condition. They get sanctioned, which is a penalty. And now we're going to give them a credit off their sentence for having a penalty and having time. I thought if you had a penalty, you had additional time. So now if they mess up, they'll get full credit for messing up, I think. Doesn't quite flow. I'm not too sure that is what is intended. I understand that there's a discussion. I'm not sure the language fits the discussion of having time count if they're in jail doing some part of in time doing treatment and everything. I get that. I'm not sure that sentence quite covers that. And of course, we get to page 10, the bottom of page 10, starting on line 15, section E. And this is where we talk about the cost a little bit. The county sheriff shall house probationers, parolees, and conditional releasees committed to the county jail pursuant to this article. The cost of the housing of probation, parolee, conditional release county jail shall be paid by the department at the per diem rate not to exceed the established amount to the department. I believe that's $65 a day. So you're shifting a state cost of greater than that to the county at a predetermined statutory rate of $65 a day, irregardless of what the actual cost of the counties are. So you are looking to criminal justice reform and saying on behalf of the state, we'll reduce the cost. Counties, it's going up. Because it's at $65 a day. Many of the jails are over 100, I believe was the testimony in June in Laramie, that many of the jails are over $100 a day. I get the incidental incarceration, but now we're talking wholesale sentencing of folks to the county jail. There needs to be a different discussion on what that cost of incarceration is that may actually increase incarceration needs without fully funding them as well from a state perspective versus a county perspective. I appreciate page 11, starting on line 30, that for those folks that are sentenced to the county jail through the probation and parole corrections process, if you will, that if there's an issue within the housing under that scenario, that the state would come in and help the sheriff and indemnify for actions and processes and procedures as they would follow state process. If I understand correctly, they would be asked to be following state process, and if there's an issue with doing that versus the normal liability that is associated with housing a prisoner in the jail now. Heading over to page 14. And again, starting on line 9 is that flow question that I'm kind of alluding to as I go through these. Does that actually flow? The court may impose at any time, modify any condition of probation, parole, suspension of sentence. Current language. The court may do that. And then it goes on to say the court may not impose new custodial restrictions on liberty unless there's a compliance violation, in response to a compliance violation. We've already talked about a whole series of things in which if there's a violation, they go to the county jail. So I'm not sure the compliance violation versus the sanction and going to the county jail. I would want to hear from the county attorneys and the judges that flows, that's the correct term for that portion, and how that fits together. I'm concerned. And why it's my issue is it comes to me in the jail, so to speak. I think, Mr. Chairman, that concludes the specific ones going through the bill, through 230, I should say. And like I say, I'm hoping that in the long run, we fund treatment, intervention, counseling, and those sanctions at the county jail level are all properly funded, with the idea that we would be preventing folks from ultimately ending up in the state pen for a period of time, and that the people, the population we're talking about, the probation and parolers, would choose to lead a law-abiding life through one of these interventions and sanctions that happens, that they change their behavior and ultimately return to our neighborhoods. Because this is the folks next door. This is the people in the grocery store the day after they get out. It's our hometown people that are coming back to us. I would like to have them come back with a different frame of mind when they do. Mr. Chairman.
Any questions, committee, for Mr. Odekoven? All right, thank you for your testimony.
Thank you.
Mr. Attorney General. Did you have, excuse me,
Mr.
Representative Stith, I guess, has something?
I apologize. Mr. Chairman, I
Representative.
apologize for
Red light is still on, Mr. Chairman.
disappearing. Mr. Odekoven, I was a bit surprised just now when you were talking about the draft bill 230. You got to page 10 under subsection E, where it would provide that the county sheriff shall house probationers. You talked at some length about that. And I guess I'm surprised at that you're objecting to that. It's my understanding that that's existing law, 7-13-1107E, and that this bill just gives it a new number. If it's my understanding that we had this discussion about the county jails housing probationers under this 90-day provision last February, and I thought, are you advocating repeal of what we did last February?
Mr. Odekoven.
Thank you, Mr. Chairman, for clarity. No, I recognize that E is existing statute. What I'm suggesting is that the other parts of the bill change what is the normal flow of sanction to the county jail to now a discussion of could be 90 days. of a sanction that would then be where it is now. It's the or post-conviction pre-pickup from the pen of 10 to 20 days at $65 a day, a few nights and or weekends, so to speak, of probation or parole violations pending other things that end up in the county jail at $65 a day, versus now we're talking 90 days of this and 90 days of that and other things at that $65 a day. That's where I'm saying that you're passing some costs back to the county at a predetermined rate that we have not talked about yet, that we may need to talk about for the long term. I hope that clarifies.
And
Senator Hicks.
along those lines, there is a proposed modification to that. If we go to page 10, or page 11 on the staff comments. So the question, Mr. Odekoven, when we get to subsection C there, it says upon agreement, the sheriffs and the director of the department. So it becomes a negotiated cost between the department and the sheriff. Is that more acceptable?
Mr. Chairman, yes, sir.
Thank you.
Any further questions? All right. Thank you. Mr. Michael.
Thank you, Mr. Chairman. Peter Michael, Wyoming Attorney General. I'm left-handed, so I moved over here. I didn't want to hit my ulnar nerve on the post. Actually, my comments, Mr. Chairman, on these bills is going to be mercifully brief. Actually, I'm going to spend a little more time talking about where the Attorney General of Wyoming fits in discussions about sentencing, probation, local decisions by local prosecutors, decisions by Department of Corrections. And the answer is we fall through the cracks on this. Under the statute that authorizes the Attorney General's powers and duties, which is 91603, which has been the subject of quite a bit of discussion in the legislature several years ago about the Attorney General giving advice to the committees of the legislature or individual legislators out of session, which is, of course, we're out of session now. I think it's been reinforced that the Attorney General is not really in a position and shouldn't be giving legal advice to legislators or legislative committees. Now, let me add a proviso to that. The Attorney General also has an agency, a very large state agency, that is managed by the legislature and funded by the legislature. So we spend a lot of time, and we will shortly, I'm sure, before joint appropriations, although this is not a budget session, talking about how we operate and certainly answering questions of the legislature about what we do as a state agency so the legislature can make decisions about our agency. But when it comes to giving legal advice, even in areas that we do a lot of work in, it pretty much, there's a lot of things that we have to actually keep our powder dry. And the reason for that is pretty simple. A bill, the set of bills you have here, obviously, potentially some of those will go to a new governor in March. And depending on how things work out, I may be the Attorney General still in March, or but I know I won't be after March because I'm retiring then. But the fact is there will be an Attorney General, and the Attorney General will do what we always do, I think, which provide written analyses to the governor about constitutionality of statutes as they appear on his desk after having gone through and been signed by the legislative leadership and ready to be signed by the governor. So we keep our powder dry on those issues, as we should, to provide that advice to the governor. So my friend Tom Jubin, who I've known for many years, mentioned, I think yesterday, separation of powers issues here between the judiciary and the executive branch with respect to sentencing and probation and parole. Well, that's a great issue, separation of powers. We've done a lot of work on that in the last few years in the Attorney General's office, but it's all been representing statutes that have been passed by the legislature, signed by the governor, and attacked by citizens or other people that have felt that the statutes are unconstitutional. We've lost a few of those as well, but we've defended them, very, very strongly, which is our role as Attorney General. So, but when it comes to saying, providing anticipatory advice on what may be constitutional or not, I'll just point to the corner over here with may I say it, your attorneys sitting over in the corner over there are brilliant attorneys. I mean, Brian Fuller worked for us as an intern. He's fantastic. He's a brilliant guy. And Tori Racinas, I know him for years and years and years. He's a great attorney. Kayla is obviously a new attorney, but you have great attorneys. And one of my best friends is down the hall, Dave Groover. He and I studied for the bar together in 1985. So that's where you get your legal advice on those types of issues from the Legislative Service Office on those big issues like, is this constitutional? Is what we're presenting constitutional? And I don't want to get in the way of that. In fact, I'm not authorized to get in the way of that. So with all due respect to my friend Tom Jubin, I'm not going to pontificate on that issue here today. And I haven't done the research anyway. Even if I did, I'd probably say something really dumb that Tori and Brian would correct for me. So that's my role, and that's where we sit. Now, on the other area that we sit, obviously, is where are we in the criminal justice process? Because, the Attorney General's office, we handle all the appeals to the Wyoming Supreme Court. We handle habeas corpus and all the post-conviction work in Wyoming courts and before the federal judiciary. And in that process, we see a lot of things about the criminal law. But what we basically do, in many cases, in our cases, we're almost always supporting what a district judge said, because if the criminal defendant won below, there's no appeal. So the state can't appeal. So the only cases we have are ones where we're defending what a district judge did and maybe what prosecutors did. But when it comes to the sentencing part, and sometimes we look at statutes and we defend the sentence that was given and say this was a legal sentence based on the statute that exists. But what we don't do is we don't get involved in the sentencing recommendations, the sentencing process. That's where you had your testimony from two seasoned prosecutors yesterday. And I think right up on the schedule here is seasoned circuit and district judges. And Supreme Court, Chief Justice of the Supreme Court is here as well. But so you've got the entire gamut of our judiciary to talk about how they see sentencing, because they're in the trenches day in and day out. But it's just not something the Attorney General's office does. We don't get involved in those. Very rarely, once in a long while, we'll have an attorney that is delegated to work with a local prosecutor and be a special prosecutor and assist on a case. It happens very rarely. And so I'm just not in a position to say, how the process, whether these statutes, what they're going to do with the process. And in fact, when it comes to corrections and correctional goals and how we can improve corrections and how the state can better spend its money to get the kind of efficiency that we want and the outcomes that we want. Well, we represent the Department of Corrections. We represent, the Board of Parole. But as far as policy and how they go through their business, they are much better situated to give you that testimony on how that should be done and comment on these bills. So basically, I'm kind of a zero here. I'm not going to be very helpful to you based on my authority, and also based on that we just don't do this work, and I don't have the knowledge base with which to present that information to you that would be helpful to you, that you should rely on. You shouldn't rely on that if I said something. Maybe when I'm a citizen, I may show up someday here and give my opinion out of left field on something like this, and you can take it for what it's worth then. But as an official, as the Attorney General, I won't do that to you or put you in that position. With that being said, any questions?
Committee, any
Mr. Chairman?
questions? Any questions for the Attorney General? Right. Mr. Co-Chairman.
Thank you. Just Mr. Michaels, for the last number of years, your staff, while they haven't rendered bizarre opinions, they've been great support to this committee, and I appreciate their involvement and your support of the staff and leadership.
Thank you very much, Mr. Chairman.
Right. Thank you, Mr. Michael. Judge Christensen.
Thank you, Mr. Chairman. Brian Christensen, Circuit Court Judge in Natrona County. I'm not left-handed, but I didn't want everybody to see a judge couldn't work the technology up here and switch this back and forth. So I'll sit in Mr. Attorney General Michael's seat. Also want to acknowledge and thank the committee as well as Chairman Christensen, Chairman Kirkbride, and representatives and senators for being welcoming to the judiciary and inviting us to participate. And we can't always give our input when we'd like to. I gave a lot more input when I was a district attorney than I can as a judge. But we really appreciate the efforts made by this committee to involve us in things that make our criminal justice system more efficient and better working for the citizens of Wyoming. Just in a general comment, the circuit court judges are always wanting more options. More options are better. And we do recognize there's limitation of resources, and especially limitations in resources in smaller counties that the counties may have that the other counties don't. Things aren't fair across the state, but in any event, we work towards making those resources that we find are very helpful in doing our job, making those available throughout the state. I'll just have some general comments about some of these bills here. I'll start as they are listed here on the Juvenile Reinvestment 221. On the crime victim compensation eligibility clarification, and the comment doesn't specifically go to the limitation, but it also just to realize that we are also not access to justice for citizens, but also our victims. And it's just ironic. This week I had a small claims case where a victim of a violent felony domestic conviction, the individual was convicted, went to the penitentiary. She went to live with her family out of state, and I'm not exactly sure how this happened, but she was not able to access victim compensation funds in the time period she was required to do so. Not sure if that's correct or not, but that was her claim. So she does have an avenue to come to small claims and get a case against the perpetrator, who's now out on parole. So you know, she had medical bills of $5,500. Now she's a single mom, and the medical providers are looking at her to recover the funds that were expended for her care based upon being a victim of a violent felony. She did not go to her PSI interview as she left the state, so there was no sentence of restitution in the district court's judgment and sentence. And so that left her, when she started getting collectors calling her about paying these medical bills, left coming to small claims court to get a judgment where the individual did show while he was on parole and did admit that he had a liability to this individual for what he did. So it was rather easy to do. But the next thing is collection from an individual who's on parole while she's a single mother and being hounded by collections. So access to justice, I think we still need to remember what we're focused on, not just for the defendants, but also for our victims and the citizens. And again, you know, everybody knows the goal here is to change behavior, modify behavior, so they don't come back to impact our criminal justice system, which kind of leads into limitation on length of probation and parole. As Mr. Odekoven said, you know, the earlier the intervention, the more likely we're going to be able to change that behavior or modify it. The more somebody is institutionalized or becomes an institutionalized offender, the harder it is to change that behavior, and it takes longer. My jurisdiction lasts for 1 year. We could have consecutive sentences that could go longer. So a lot of the information and the things addressed don't really pertain to circuit courts. But I would just looking at the length of parole, we do have statutes that allow for our court supervised treatment programs to last up to 3 years. This parole lasts up to, I think, if I'm reading this right, 30 months. And we're dealing again with institutionalized offenders. We do have parolees out in our drug court programs. And setting a barrier on that length. Most of them take, 18 months to 2 years, but there are individuals that take longer. And so if we get butted up against that 30 months, it may be something inconsistent with our court supervised treatment 3-year programs that are allowed under statute to extend probation out to that length in order for them to participate in those drug court programs. Excuse me. One of the things talking about probation too, and I didn't really ferret out from the information of the data, in Natrona County, we have a standard condition now in our judgment and sentences that allows for probation and parole to move to unsupervised probation, usually upon certain conditions. Either they have completed their counseling or paid their financials, or the court may have set a date, such as if you had a potential 2-year supervised probation after 3 months or 6 months. So the length of probation may not be taken into consideration on some of these. It allows probation and parole upon their risk assessments. Well, let me back up a little. It is rare for a circuit court judge to ask for a pre-sentence investigation. We don't generally ask for PSIs. We may ask for a victim impact statement. We may get substance abuse evaluations. We may get domestic violence inventory assessments to determine what type of counseling would be most effective while somebody is on probation. Once that trade-off, though, is to not ordering those PSIs, which takes the time of probation and parole agents to do those PSIs and then come back with us. That's why we allow for that initial supervised probation and then allow for probation and parole to move them to unsupervised probation. Supervision leads to compliance. As you can imagine, unsupervised probation, there's a lot more non-compliance with orders to comply with counseling or with any other conditions that the court may set on that unsupervised probation. If it's supervised, it leads to a lot more compliance, as would make sense. Just to comment on those of us that have been around for more than a couple decades in the criminal justice system, when we first got out of law school, there was no such thing as domestic battery. It was all included under battery, and assault and battery. It was all included in assault and battery. When the recognition came that there needed to be more focus upon these acts of domestic batters, one of the basis in my training back in the 90s was based on a Department of Navy study that showed that an individual who committed domestic battery was less likely to reoffend and not commit another act of domestic battery if they're on supervised probation. They tested other counseling programs, no counseling programs. The key factor in those studies was they were on supervised probation. Then that led to lack of recidivism. And if they were on unsupervised probation, the recidivism was the same as whether there was no probation at all. So I just want to leave you with that and limiting the amount of probation on some of these cases. And we also see that in something we've not really addressed, and that's probably more for the district court judges. I don't deal with that, is sex offenders and pedophiles. If they are on probation, there has been the trend throughout the country to have them on supervised probation and monitored longer than normal probations for other offenses. As to Mr. Odakoven's shall and shall not, I don't know. I don't know how this will all work either, but it's one of those, we'll find out, I kind of think. But I'll just also say there's a concern about incarceration. We do have U.S. Supreme Court cases out there that if an individual is incarcerated for a reason, they need to be reviewed by a judicial officer within 48 hours. And if that's not the case, there are ways, such as in our drug court programs, that they sign consents to make that sentencing longer. Under our statutes, it's up to 30 days in a drug court or court supervised treatment program. But they have already known that, accepting to get into a drug court program and signed waivers to that effect. And I'm not sure the mechanisms that would be used to justify those incarcerations for probation and parole sanctions. But that's, I'm just putting that out there. So I'm sure some people have thought about that. As for anything else, let's see. I think I've hit mainly the topics there, Mr. Chairman. Any questions, I guess?
Thank you, Judge. Any questions for Judge Christensen? Right.
Sorry I put you all to sleep.
No. Thank you for your input.
Thank you.
Thank you for your input. And Judge Day?
Thank you, Mr. Chairman, members of the committee. First of all, we would like to second Judge Christensen in thanking you for being so generous in continuing to solicit the input and perspective of the judiciary on the important issues that you work on and your important justice reform initiative. And I want to reassure you that I believe the judiciary totally understands that it's the prerogative of the legislature to decide how to implement policy through statutes. And regardless of what the judiciary might believe themselves about that, I think you can rest assured that the judiciary is committed to faithfully applying the rule of law, and that we are committed to. And you know, whether some of these initiatives get ended up becoming law, if individual judges didn't particularly agree with that, I am confident that they will do their best to apply those equally across the board. That's our job, try to follow the rule of law. Having said that, I would like to try to give you some perspective from the judicial point of view, raise some possible considerations for you on some of these drafts, and suggest some potential consequences that could occur depending on how these might go forward. And of course, I need to give you that disclaimer that I can't really speak for all of my colleagues. I really am speaking, I guess, from my own experience and from having the benefit of speaking with a lot of my colleagues, but I certainly can't speak for each one of them. And to the extent that there might be enough time, Mr. Chairman, perhaps my colleagues might cover anything that I might have forgotten or screwed up, or just to give you their own perspectives on some of this. But if we take a look at these drafts, the crime victim compensation eligibility, I don't have any concerns about that. And I'm not sure that would be anything that the rest of the judiciary would be terribly concerned about. If we move on to the two drafts that deal with the length of limitation on length of probation and the limitation on length of parole, then I can at least start to speak to both of those generally. We talked the last time in September at your meeting about how sentencing is a very individualized and specific process that we have the district judges are giving a tremendous amount of discretion in most cases to impose any sentence from probation to the maximum allowed by law. And there are a few crimes for which there's a mandatory minimum, but that's not most crimes. Most crimes, it's all the way from, let's say it's a 10-year aggravated felony assault. So you could determine that under the specific circumstances of that case, then probation would be appropriate. Or you could decide this is a situation that deserves a maximum not less than 9 and not more than a 10-year sentence. And because of that huge discretion, the judges are mandated to consider lots of different things. We're to consider the crime and its circumstances, the character of the defendant, the aggravating and mitigating circumstances, the effect on the victim, community safety, the impact on the community. And, in short, it's definitely not a cookie cutter process. And so these two bills, these two drafts, while I was impressed with the report that was provided to you, and I'm very impressed with Mark and his people and what they've done, and I kind of understand, how those statistics have translated into the suggested minimums of probation and parole. I would say that because of the number of factors that you need to take into consideration in fashioning what you think is a just sentence in any particular case, the fairly strict limitation on the length of probation and parole would be of concern to the judiciary, and I think it's important. Maybe it was Mr. Riedel yesterday, but someone mentioned that probation and parole is a penalty. It is a significant restriction on a person's liberty. And so when you're fashioning a sentence in deciding, on one hand, the length of a period of probation, or on the other hand, the difference between a minimum and maximum sentence, which is going to affect how long a person is on parole, that is taken into consideration in the impact of a sentence. Sometimes, for example, you might think, well, I think we could take a chance on probation on this individual. But if I can only put this individual on probation for 3.5 years, is that going to be a big enough incentive for the individual to conform while he's on probation? Is it going to be a big enough incentive for him to be deterred in the future? Does it provide that kind of general deterrence, which of course is one of the goals of sentencing, to others? Or is it going to be perceived that that's not really much punishment, or it's not enough punishment? It's not a long enough period of probation. And when we talk about punishment as a goal of sentencing, it's also talked about as retribution, which is really could be described as the community's recognition that an appropriate sentence has to be imposed for a particular crime and its circumstances, to continue to have faith in the criminal justice system, to reinforce societal norms that this is an appropriate sentence and it's going to serve the goals of specific and general deterrence, as well as be, try to address rehabilitation. To the degree that probations or paroles might exceed these recommended limits, we talked before about the fact, and it's been raised here yesterday, that there is already a process by which probation can come back to the court and seek an early discharge for offenders on probation. I think I testified last time that in my experience and my knowledge of many other judges, that they frequently grant discharges of probation, often at the halfway mark. It is curious to me about the statistic that 60% of felony probation terms are greater than 3 years. That's contrary to my experience. It's contrary to the experience of my colleagues here. And I think I told you last time that it's rare that I would impose a probation term of more than 3 to 5 years. However, there are situations where it is important to consider a longer term of probation or a greater period of parole. One of the situations most often cited by my colleagues is when you have sex offenders that to the degree that you don't want to just lock up every sex offender and treat them the same and give them a maximum sentence, but hope that they can be rehabilitated and not be a safety risk to the society, then you would like to give them, maybe they need some incarceration, but you'd like to make sure that you made the right decision. And therefore you might, if you don't incarcerate them, you're going to put them on a longer period of probation to make sure that that happens. Give them the incentive to continue to conform and not reoffend, or have a longer headroom between minimum and maximum for probation, so that any period of incarceration they serve, we make sure, number one, that they're reforming while they're in an institution, and then they can maybe hit their minimum number. And if they aren't, they're probably not a good risk to be out, so they're going to be doing a lot more than their minimum number. If they get out, then we need to give them an opportunity to show us that they will conform and continue their reform while they're on parole. And I think judges think about, how will the public perceive this, and how can we protect the public? And it would be, it might go through the mind of a judge if you're thinking of, well, okay, I'm going to give, there has to be some incarceration. Probation just unduly diminishes the severity of the crime. So it's going to be 1 year, but I'm going to put a 10-year, a 1 to 10 on him, because we need to let the public know that there was some incarceration, but we're going to be making sure that this individual will be reforming, and he'll have supervision, and he'll have hopefully resources to help not reoffend. And if a judge is looking at, okay, I can only do 42 months, so it would be 1 to 4.5 years, is that really enough time? Is that going to serve the concern of community safety and the perception that this was an appropriate sentence? Will that potentially translate into a higher, a judge's calculus that maybe we need to do a higher bottom number, and the person ends up having to go to prison for a longer period of time, which would be an unintended consequence, I suppose, of having a limitation on parole. There are some good reasons in certain cases to have long periods of probation. Again, not only the sex offender situation, but there are some individuals, and particularly
Mr. Chairman. Sorry, Judge, to interrupt, but I appreciate your comments. I want to make sure that we're talking about the same legislation. In Working Draft 231, a lot of your comments have been prefaced around sex offenders, batterers. However, it's my understanding that this draft legislation only applies to one, first-time offenders, and two, we're not talking about murderers, sexual assault, first, second degree, aggravated assault, battery, arson. We're not talking about those violent crimes, Judge. We're talking about non-violent offenders. Is that your understanding of the legislation?
Well, yes. Oh, I would, Representative Olson, Chairman, it does accept certain of the most serious crimes, but there are plenty of other offenses that have significant potential maximum terms in prison, that this would limit the opportunity for the judge to impose what they believe would be an important part of the sentence, whether it's the length of probation or the length of parole. So I do think that those, there are plenty of other offenses where this might take place, and that leads into what I was just going to say. I've had the opportunity to run a treatment court for 14 and a half years, and I've had countless people in my treatment court tell me, Judge, I do really great when I'm on probation. In fact, I never screw up. And the minute I get off probation, I screw up. And that doesn't mean that judges put addicted offenders on maximum terms of probation or have a huge difference between min and max, but there are situations where people really do better on a longer probation. Longer probation might be helpful in making a condition of probation that they pay, that an offender pay all of the restitution. And in certain situations, there might be tens of thousands of dollars that they might have to pay in restitution. And one of the things that's commonly done is as a condition of probation, you have to pay your restitution, and you can put together a payment plan with your probation officer for approval by the judge, and they will then have to do that and make a good faith effort to pay. If they only have 36 months, in certain situations, that is not going to be feasible. I would say both with respect to length of probation and length of parole, that if it were decided and the legislature decided ultimately that there should be a specific number that in limitation, I would think it would be really important to consider having a safety valve for the judiciary, for the situations where they feel like there are good and demonstrable reasons why someone should have a longer period of probation or a greater period of parole, and be able to demonstrate that on the record. There are examples of that in the law already, and I guess the ones I could think of quickly are actually in the juvenile code, where the juvenile code sanction, they give sanction levels, seriousness levels to offenses 1 through 5, and they say, okay, judge, if your juvenile delinquent is at sanction level 3, here are the things you can do. And it doesn't include, for instance, the Wyoming Boys School or the Wyoming Girls School. But then it goes on to say, however, if in the judge's discretion you feel that that is an important goal in your case, then you can do it. Similarly, in the juvenile code, it says that the multidisciplinary team makes recommendations to the sentencing judge, the juvenile judge, and the judge is to accept those recommendations. But then it goes on to say, provided, however, if the judge thinks that something different is necessary, he shall put on the record why he is doing something different than the recommendations from the multidisciplinary team. And it kind of goes back to the idea that at the time of sentencing, the judge is the one that should have the most information. They have the benefit of the pre-sentence investigation report. You hear from the defendant and their attorney. You hear from the victim and the victim's advocates. You hear from the prosecutor, and you see the criminal history, record on probation and parole, and you try to fashion that individualized sentence that you hope is just. So I think can move on to 217, modification of probation.
Mr. Chairman, before we move on, I do have a question on 231. Judge, based on your comments about the safety valve, and I appreciate those comments. I'm wondering, so I'm looking at bill draft 231, page 3. The amendment under 713-302 begins on line 6. For example, the limitation on probation is prefaced with the clause unless otherwise authorized by law. Now, my understanding of that at least would be in the juvenile code example that you gave, Judge, that maybe that would provide sufficient flexibility. Because if it's already authorized by law, I think you're going to be able to, any judge is going to be able to expand beyond that. And so I guess my question is that enough of a safety valve, or are you looking for something more? And if you are, I guess I need a little more guidance on what that would be.
Well, I don't, Representative, I'm not sure that would be necessarily referring to, this is in the criminal code, and it wouldn't be really relevant to the juvenile offenses. So I wasn't suggesting that this would limit the discretion of the judge in the juvenile situation, but it does say any term of probation under this section for a felony shall in no case exceed 42 months. And so unless there were a specific exception in an individual criminal offense statute to say you could put them on probation for longer, then I think this would be the limitation for the length of probation, except for those offenses that you pointed out were exempt from this. Back to 217, modification of probation. The only thing I noted there was on page 2, line 21 through 23. In determining the period of probation or a modification of existing probation, the court may consider. I think it's fine to have, those look like reasonable things for the court to consider. It occurs to me that when it says may consider, you wonder if that means that's the only thing you consider, or is it you may consider without limitation, or you may consider factors including. and to the degree that it omits other factors that you can consider, then I'm sure that there are other situations that a court would want to consider in an individual circumstance in how they might modify probation, and it just hadn't been listed. So I think it's a little vague, and that might benefit from some clarification. Finally, 230. Again, I really think it's hard to argue with the proposition of trying to give probation and parole more resources in terms of sanctions and incentives for probation and parole folks. That makes a lot of sense. Especially it makes sense, and as we've heard from several folks, that if we can provide these options for treatment and services up front, one of the practical hurdles, at least right now, is that a lot of the things that are contemplated as additional sanctions and incentives, the resources for those just don't exist. And we talked before, Judge Tyler mentioned at our last, at your last meeting, that there are no ACC programs in the whole western half of Wyoming. There are very few inpatient treatment centers, and you heard from the public defender yesterday that there can be 6 to 9 month waits to get into treatment. One of the sanctions that's linked to rehabilitation is 90-day jail sentences where you can get substance abuse treatment. There aren't a lot of jails in Wyoming that currently provide substance abuse treatment in-house, at least not that I know of. I know there are some. So I'm not sure that the resources that we want to front load on probation to try to minimize reoffending and eventual prison really exist. So that's a resource issue. And I think, I talked with Mark on Monday at length and his people, and we had I thought, a great conversation. And I think he believes that maybe some of the savings from this reform can be plowed into the, but they don't exist right now across the board. Some more specific points. I guess I would draw your attention to the staff comment on pages 19 and 20, where they basically say it's unclear if the court can only revoke probation for new felonies or for an individual who absconds. And I would agree with that, having just kind of read the overall draft, that it is unclear whether the traditional probation revocations that have happened in the past would now only be available for someone who committed a new felony offense or absconded. And similarly, and as Mr. Odekoven highlighted, on page 14 at 713-304A, it's unclear to me what that really means and what the process is for probation revocation on a compliance violation, whether the court can revoke probation based on compliance violations where incentives and sanctions were already undertaken and unsuccessful. Conversely, it's unclear to me what about if probation and parole, they have these you shall do this for sanctions and incentives for these compliance violations. What if someone commits a new misdemeanor offense a violent misdemeanor offense, domestic battery. Can they circumvent this and choose to immediately seek to revoke probation with the district court, or not? And once it gets to district court, it's unclear to me what the process is. Do we just fall back on the old process, or does this language that I think is somewhat unclear at 713-304A suggest that we're supposed to be doing a different process based on the process that was set up for the compliance sanctions? If we go to page 22, lines 15 through 22, that's 713-1105. And it basically says that a court couldn't put someone on intensive supervised probation unless they were considered to be a high risk for reoffense based on a validated risk assessment instrument, which we know right now is COMPAS. I have some concerns about that. And I think we talked about that last time as well. But first of all, COMPAS is not a good instrument for assessing sex offender risk. It's not a good instrument for assessing DUI offender risk. I think the department is working on specialized instruments in those categories, but right now, that's not a great instrument for that from the information that I have. And the other concern I have is, again, repeating myself from last time, I think, but it's better to have, a reasonably helpful instrument than not have any instrument at all. But these instruments are not precisely predictive, and they can over-assess risk and they can under-assess risk. And it concerns me that if a court would think that it would really be helpful to have an offender knowing as much as you possibly can about the situation, to have them on intensive supervised probation. But gosh darn it, I can't do it because the COMPAS assessment on the pre-sentence investigation report says they're only a medium risk. I believe that it would be commonplace for district judges to tell you that they have encountered many times the situation where they get to the end of the pre-sentence investigation report and have reviewed the criminal history and all of the personal history and the crime and what happened, and then it's like, whoa, this person's assessed as a low risk or as a medium risk. And I mean, just so that there's some basis in this, I just had a sentencing, and this individual had a trial in my court. He was not only convicted of aggravated assault and battery on his girlfriend, who he nearly beat to death, but he had been charged with enhanced penalties for having committed 3 similar felony offenses in California. And he was sentenced because of that to life in prison mandatorily. It was reversed by the Supreme Court for trial errors. It came back, and the individual pled guilty to the aggravated assault and battery in the state of Wyoming. The prosecutor dropped the enhanced penalties. So instead of facing life in prison, he faced a maximum penalty of up to 10 years. And so we did a new pre-sentence investigation report. And this individual he was 39. He started his criminal history at 19. He had at least 7 misdemeanor convictions, including assault on a police officer, assault on a transportation officer. He had 3 DUIs. He had 3 prior felonies. One of them was a felony assault involving serious bodily injury to a co-inhabitant. And he had been on parole twice. He'd had parole revoked. He'd been to prison. He'd been to jail. He'd been on probation. And he was identified as a medium risk to reoffend. And so the instrument is not perfect. And it seems like those are the kinds of situations where, to the degree the court might think it would be appropriate to try to err on the side of, okay, we can still protect the community if we have ISP, but I can't do it because this instrument and that algorithm that Matt mentioned don't permit it. So let's see if there's anything else. I'm sorry, taking longer than I thought. I guess I think that's what I have, and I certainly can stand for any questions. And then again, if you have time and my colleagues had anything to add, I'd certainly invite them to do that if that was your pleasure, Mr. Chairman. So, any questions?
Thank you, Judge Day. Committee? All right, Judge Tyler?
Thank you very much.
Good morning, Mr. Chairman. I just wanted to maybe clarify something about 231 and some questions about that limitation on probation. On page 1 at line 12, this is referring to an existing statute, 713-301. I refer to this as a deferred prosecution statute. It allows an offender to be placed on probation for a period of up to 5 years. And if they're successfully discharged from probation, they will not have a conviction against them. And so there is and this is existing law, on page 2 at, I believe, lines 4 through 7 or 8, those offenses that would not allow an offender for one of the, oh, I'm sorry, it would be entire subparagraph A on page 2, line 2 through line 12. It would disqualify an offender for certain offenses to receive this special treatment where they would not have a conviction against them if they were successful on probation. The existing law on that statute is a 5-year maximum probation term. So changing it to 42 months, I don't know that those of us who have reviewed and commented with Judge Day have much of a problem about a 6-month difference. The statute that I think is the aim of the comments by Judge Day, and he expressed some concerns that we relayed to him, is on page 3 at line 4. It's 713-302. This is the general probation statute. What you don't have in this bill draft is subsection A, which basically says, except for, I'm paraphrasing, but basically for like felony murder or capital crimes or things like that, then the court can place somebody on probation up, and I'm paraphrasing, up to the maximum terms provided by statute. This is not one of those special statutes where if the probationer is successful, there's no conviction. This is after a conviction. And what lines 8 through 12 on page 3 do is impose a limitation on probation for those kinds of crimes, which includes many more beyond those that were disqualified under that deferred prosecution statute I just mentioned. And it is really 713-302B under draft 231 that Judge Day and Judge Blumel and I, in discussing this with him, have some concerns and about that tension between coming up with an individualized sentence and an individualized probation based on all those circumstances Judge Day was referring to, with this limitation that may be imposed to 42 months probation. And I just wanted to offer that clarification, Mr. Chairman, if I'll stand for any questions.
Thank you, Judge Tyler. Committee, any questions?
Chairman.
Mr. Co-Chairman.
Judge Tyler, when we look at this, really, this bill is largely about that 42 months, which creates some unintended consequences, like it really binds your hands on some area where you need the latitude.
Yes, all those things that Judge Day mentioned about, for example, a sex offense, where there's a need for more supervision, or based on an individual's circumstance, perhaps an individual needs more supervision to accomplish successful treatment and that sort of thing beyond 42 months. Those are the areas mostly of our concern. These other statutes, I guess just to expand upon that a little bit, on page 4, line 1, statute 35-7-1037, that's a drug or a controlled substance deferred prosecution statute, if you will. There's no conviction if the probationer is successful in being discharged. There's not a conviction for those qualifying controlled substance offenses that are allowed under that statute. We don't have a problem with that. It's mostly aimed, I shouldn't say problem. Our concerns are mostly aimed at 713-302 on line 4 on page 3.
Mr. Chairman.
Senator Nethercott.
Thank you. Thank you, Judge Tyler. I appreciate your comments and directing the committee's attention to the most problematic version of what I identify in this bill, and share your concerns about the limitation of putting a 42-month probation term for all crimes, essentially. However, the reason why that's being proposed and the reason why we're all here today is because of a failure of the criminal justice system to properly use probation, resulting in increased costs. And so we are evaluating that very, very carefully. A challenge and frustration I have is most of the data and information we're getting, particularly from the judges and from the court system and prosecutors, is all very anecdotal and all very inconsistent based on practice. And there is no empirical data that we have to rely on. So what happens is these problems are solved by the legislature because the people in charge with doing that are not solving the problem, and the problem persists. And so we here in the legislature are required to solve it, and it doesn't satisfy anyone's needs, and everyone is going to be unhappy, similar to a courtroom. So what I'm asking for, and I hope to hear from, is what crimes specifically, and I'm not talking about how long somebody should be on treatment, because my experience in those courtrooms is that you cannot get a treatment provider, whether it's substance abuse or mental health, that's ever going to say somebody is fully recovered and it's time for treatment to stop. So really, that's a lifetime situation. So probation is going to be appropriate for life, particularly for sex offenders, right? But at some point, the criminal justice system's relationship with these individuals has to stop. So what I am looking for is a balance here between those crimes that truly need those longer probation terms. And I'm not talking about continuation of treatment for life, but really those crimes that require an appropriate balance of punishment, where that 42 months is inappropriate. And so some of those violent crimes and aggravated assault would not be appropriate for a 42-month sentence. But prison may also not be appropriate either. And so what I would like to do is a thoughtful consideration from both the prosecutors in the room, defense counsel, and the judiciary about what those crimes are. And again, I want to stress that from my perspective, this is not treatment based. This is about appropriate punishment for the balance of the crime to the punishment and what that needs to look like. So with that, that's a question to you that I don't expect you to answer right now, but certainly hope we hear some feedback from those in the room that practice in this area of law, so we can provide some well-balanced responses to this issue.
Mr. Chairman.
Judge.
Senator Nethercott, I don't have a full response, I guess, to your question to me. I do have a partial response. The partial response is, if you look at page 3, line 4, Wyoming statute 713-302, the existing law basically says that we can impose under those crimes for which we are allowed to consider probation, a term of probation up to the maximum term provided by statute for imprisonment. This is anecdotal, but what I do, I try and give the Department of Corrections, Probation, and Parole offices or agents an ability to work within a probation sentence that I would impose upon a defendant. I do this particularly in Fremont County because there seems to be an understanding that it works well. I can't say that I've had a request in other places that I sentence individuals, but Fremont County very frequently, I will put someone on probation for, let's say, for some particular period of time, unless sooner discharged. That gives the probation officer or agent the opportunity to assess, do I need to commit more resources to supervising this individual, or is this individual got it? Maybe the agent can do an assessment, a follow-up assessment, to see if they pose some sort of a further need to afford supervision. But they're always free to come to me and ask for an early discharge. The same with the state. The prosecutor can file a petition to modify probation under Rule 39B of the Wyoming Rules of Criminal Procedure, to modify terms of probation to limit the length of the probation if it's not working out. I've had many instances where I may include a condition of probation that is not suitable for that particular individual. And I've had agents and prosecutors come to me and say, will you remove this as a term of probation? And it would tend to shorten the term of probation as well. So something is, I guess, as uncomplicated as giving the Department of Corrections more latitude to make assessments about where they want to devote their resources, and devote the resources to individuals who may need more or less supervision, seems right to me. And so I try and accommodate that by just saying, unless sooner discharged. Putting this 42-month, for example, limitation, where you have a statute that it's a maximum 10-year imprisonment, but I can only put them on probation for 42 months, it makes me pause at the time of sentencing. Is this going to work? And so I just wanted to I guess, highlight that is the essence of what would go through at least this judge's head at a sentencing with this legislation in place on most of the sentencings that I would do where I'm considering probation. And I'd really have to factor in this limitation as to how effective it may be as to that individual that I'm required to assess on that individual's characteristics. I know it was a long answer for a short off the top of my head response, but I don't know if you have any questions about that.
Committee. Right. Thank you, Judge Tyler.
Thank you.
Judge Plumel.
Thank you, Mr. Chairman. I'll try to be very brief. I think that my colleagues have done a very detailed response, and I'll just have a couple of follow-ups. I guess one of the items that I do want to point out and have the Joint Judiciary Committee consider is going back to the issue of the 713-301 and the limitations on that. I'm sure that all of you are aware, but I would like to take this moment to point out that I, as a district judge, can only grant a defendant a 713-301 or deferred prosecution with the consent of the prosecutor. Now, with all due respect, not to pick on a certain member of the committee who happens to live in Laramie, I know that he would regularly ask prosecutors in matters before me to get treatment and consent under 713-301. And I would just posit to the committee to consider whether or not limiting the term of probation to only 42 months would further restrict a prosecutor's willingness to consent to that. And I submit that, frankly, I think it probably would. Because I do have 713-301s that the prosecutors consent to, that require 5 years of probation instead of just 3. So that 18-month differential may have some unintended consequences because instead of granting a 713-301 to people, it may end up resulting in a felony conviction. And I will also point out that particularly one of the items that a 713-301 seems to be used for by the defense bar and the prosecution is there may be allegations of second-degree sexual assault that may actually be amended down to third-degree sexual assault and placed on 5 years of supervised probation under a 713-301. Taking that away may have another unintended consequence of causing people to have to become registered sex offenders for the rest of their lives and those kinds of consequences. So I think those are balancing factors. I'd just like to point that out. Neither Mr. Jubin nor the Prosecuting Attorneys Association have commented on that. And I think that may actually be a factor that will affect justice. The other item that I don't believe has been mentioned is length of probation sometimes is utilized by me, and I know by some of my colleagues, for a long term of probation for people to pay back theft or embezzlement. There are business entities that will have particularly an employee. You can even have them a family member who will steal. They'll get caught. They may say, oh, they've already had their job lost. They've had their careers ruined. They don't need to go to prison. And all I care about is restitution. And they don't have the ability to pay it back in a short period of time. Certainly, any conviction can be a civil judgment. And as Judge Christensen spoke about, I can enter that civil judgment and say, okay, now it's up to the victim to go ahead and collect that, which again is a policy choice that I think you folks have. But that is another factor that goes along with this 42-month limitation. That think about your business members in your communities and how that may or may not affect them in these kinds of situations. The last item, Mr. Chair, that I'll comment on is the intensive supervised probation. One of the other comments that and with all due respect, I realize this is expanding beyond the specifics of this legislation and proposed legislation and the comments here today. But I generally have in my jurisdiction 4 different communities that I deal with. One is Star Valley, one is Kemmer, Evanston, and Bridger Valley. I have intensive supervised probation available in my jurisdiction in only one of those 4 communities. I cannot put an individual on intensive supervised probation in Star Valley, Kemmer, or Bridger Valley. If I place them on intensive supervised probation, they have to move to either Evanston, Jackson, or another location that has intensive supervised probation available. Sometimes that's particularly important when you're starting to talk about 4th or subsequent offense DUIs. And it can also come about if someone is actually entitled to probation in a plea agreement or some sort of a specific sentence on a DUI with serious bodily injury and some of those items. And I question the value of intensive supervised probation to me in those communities is actually very great. And if I don't have that available, a lot of times I only have the option of sending them to prison and putting them on parole and having the parole system be responsible for it because of the high risk to the community. Thank you, Mr. Chairman. And if any of you have any questions, I'll do my best to respond.
Thank you, Judge Blumel. Committee, any questions?
Mr. Chairman.
Senator Nethercott?
Thank you. Briefly, Judge Blumel, thank you for your comments. Your initial comment where you were concerned at the prosecutor's willingness to consent to 301 dispositions because of the reduced probationary term. following up from the testimony that we heard yesterday, the basis for that reduced probationary term is based on empirical data that we've received from the Council of State Governments. How do you think the court and the prosecutors and the defense bar are going to apply this data that we've never had before to influence these decisions? I mean, I hear what you're saying and share those concerns as well, that they just don't like it because they prefer the arbitrary number of 5 years or 5 to 8 years because it feels comfortable. The 4 to 6 term, those numbers we frequently grab for in the system, which are just based on how we feel rather than what the data suggests or reveals for actual performance outcomes. And so how do you think that the court and those prosecutors appear in front of you will use this data in making those determinations moving forward, if at all?
Well, thank you, Mr. Chairman, Senator Nethercott. I can't speak for the prosecutors, the defense attorneys, or for my colleagues, but I'll go ahead and speak from my personal perspective. This information does not surprise me. The only question I have, and maybe you can ask this, and maybe you know this already, and I just haven't gleaned this from the details of the statistics, and that is when they talk about the length of time that somebody ends up having their probation revoked and going to prison, is that the second or the third time that their probation has been revoked and reinstated? Because frankly, from my perspective, I will tell you this does not change anything in my mind from what I see from the bench, in that most of the probationers that violate to get their probation revoked do fit entirely within that 3-year period of time. But I do have some that go beyond that, and they particularly come about with sex offenders. And sex offenders, if I've put somebody on probation with a sex offense or maybe failing to register as a sex offender, it is interesting that I do have those violations where people will appear in locations that they're not supposed to be, such as rec centers, areas where young people are available for them to have contact, and probation for a lengthy period of time can keep them out of that. Frankly, those are people that I think fit in at margin where if they're successful in 42 months and they're done with probation, it would be a crime for them to go to a recreation center and be there till they're convicted or found and proven beyond a reasonable doubt to have done something that's a violation. So I guess the thing I would say is, frankly, Mr. Chairman and Senator Nethercott, this really doesn't change anything to me. The only way that it would change it is if I have somebody that I'm thinking, okay, do I put them on probation and I think they fit the longer period of time, or do I have to actually result in incarceration because I think I need to do that? That's where that decision would probably come. Thank you very much, Mr.
Thank you, Judge Plumell. Senator Hicks.
Mr. Chairman and Judge, and I'm just going to make this as a broad statement to all you guys, the members of the judiciary. You by far have the toughest job in the state of Wyoming dealing with these issues. In my 8 years on this committee, we have given tremendous due deference. The circuit court judges always tried to provide the maximum amount of discretion, give you the tools that you needed to do the job. But my concern is, and Judge, I think you just illustrated, is what we've been presented with as a legislature is empirical evidence. And I don't want to characterize, but what I think I heard today based on the testimony, not just yours, but everybody's testimony, is nothing's changed from the perspective of the judiciary with the empirical evidence that we have to deal with. And we have a shared responsibility. And I think Senator Nethercott's spot on. What we need is precise recommendation, because here's the dilemma that we're facing. If we do nothing, we're going to have to write a check for $51 million. That's just for the prison system. And because this system we have now is a revolving door, When we look at your caseloads at the circuit and district level, a lot of this is recidivism coming back in. So then we're going to have to put more judges, more courtroom security, and it is a spiraling out of control fiscal nightmare. And I just went through an election cycle, and you know what I heard loud and clear? I don't want my property taxes, I don't want my income taxes, and I don't want my sales taxes. So we have a dilemma here. We can't afford the programs we have right now. It's not working fiscally. We wouldn't be increasing our recidivism rates if everything was perfect. We got to come up with solutions. And right now, the solution that we've been presented is based on empirical data. What we need from the judiciary is empirical data to start making better decisions. And until we have that, and so the suggestion I'm going to make is that we continue to put together a list of things, engage with CSG, any of these nonprofit organizations. I'm going to tell you, I'm sitting here today and I'm looking through this bill, and what I've heard as a testimony is really disturbing, because I understand the dilemma that you guys are faced with. And thank God that you're willing to step up and do the job. I'm grateful. But there has to be a shared concern with the dilemma that we face as a legislative body, and to go back to our constituents and say, look, we're going to do the same old thing. Write the check, folks. And so we're at loggerheads, and what we need is a partnership. And I think it gets right back to what Senator Nethercott. I need specifics. Where does the 42 work and where doesn't work? What are those specific crimes? So I appreciate that you guys, I mean, we knew when we passed this out in Laramie. I think my comment is the best way to spur a discussion is to have a piece of draft legislation. It's done that, but we can't stop here. And whether we pass this out or not today, this discussion needs to go on, and we need to have a shared mutual appreciation for the dilemmas that all of government, all three branches of government are dealing with, because you got the third branch sitting here with DOC, and they're the guys that have to deliver. Now, we're going to provide the funding, you guys provide the direction, and DOC has to deliver the goods. And quite frankly, I'm glad this discussion's happened, but I think we're a long way from this. And so I'm a little concerned based on some of the testimony, from the judiciary. So I just want to reiterate what I think I heard, because sometimes what you think you heard and what you actually heard are two. So I don't want to mischaracterize. One of the things that left me with pause for concern was if you implement this law, we're just going to institute longer sentences. And that's what I thought I heard. And I don't know if that was implicated. And the other part is if you we're more comfortable with the status quo than we are trying anything new. And I understand that. It's easy to do the same thing we've always done. But, remember what Albert Einstein said? Doing the same thing over and over again and expecting different results is the very definition of insanity. And what we are doing is, it's not justice, it's not rehabilitation, and it's not responsible. And so we have to come up with a responsible alternative. And that's what we're trying to do. And so I'm just telling you, it is a dilemma, and it just is, I may not be on this committee in the future. We've spent, 4 years on criminal justice reform, and we have made some minute progress, but we've got a long ways to go. And I'm just telling you, the taxpayers of the state of Wyoming are demanding results. That's the dilemma that we have, Judge. So I just hope that we can get something out of this. And quite frankly, I'm going to tell you where I'm at. I'm desperate to try anything.
Mr. Chairman?
Anything.
Mr. Chairman, Senator Hicks, I appreciate, and if you heard from me or my colleagues, particularly I'll speak for myself, an indication that, I'll just increase the sentences. Please let me correct my statement, because that certainly is not my intent. I have to tell you that I won't rule out that will come into argument when I have to do sentencing. I can expect fully that I'll hear that, And I think that you could visit with the prosecutors. And I give all due respect to my colleague and good friend Tom Jubin when he said, might this happen? I don't know. I'm just here to talk about one of the potential things. If I may, Mr. Chairman and Senator Hicks, I actually posit to you that maybe the group that you have with the Department of Corrections has the statistics, and they can tell you what type of offenses do end up having the probation revoked after the 42 months, and more importantly, even after the 36 months. And they probably have that empirical evidence that the two senators, Mr. Chairman, have inquired about. With all due respect, it is an honor for me and my other colleagues on the district court bench to serve the people of the state of Wyoming. And we frankly don't have the tools to come in here other than our anecdotal situation and provide that information to you. But I submit, Mr. Chairman, that you have people that does have access to all of that information, and how they choose to present that information and what questions you ask certainly can provide that. And I will assure you that all of my colleagues and I will work very closely with the legislature, no matter what it is that you choose to do on these important matters. And trust me, we understand very much the dollars that are involved. Every time we make a decision that we're sending somebody into the system, we know how much that costs more than most folks do. So thank you very much, Mr. Chairman and members of the...
Mr. Co-Chairman?
Thank you. Judge Blumel, let me just throw this out and make sure I'm kind of hearing some of the bigger picture on this. And the issue is, one of the things I'm hearing is when we think about this from a public safety standpoint, I think that's also a top priority for the legislature. From a public safety standpoint, the judiciary has concerns that with some of these limitations, it could result in either earlier releases from probation or parole that could increase a threat to public safety, and the alternative, based on the concerns you've expressed, is keeping public safety in mind, is possible increased incarceration terms.
Mr. Chair, Senator Christensen, yes.
Okay. Thank you.
Okay, thank you, Judge.
Thank you.
Can we move on to the Department of Health?
Morning, Mr. Chairman, Mr. Co-Chair, members of the committee. My name is Franz Fuchs. I'm a policy analyst with the Department of Health. We collaborated with CSG on their presentation, and I believe I'm on the agenda to be able to answer any technical questions on that one component of that collaboration. So I'd be happy to just hang back in the audience and wait for their presentation. And if the committee has any questions on those particular pieces, answer them at that point.
Okay, Mr. Fuchs, thank you. That's all the program folks we had, but the Chief Justice might wish to weigh in. We'd invite that.
Thank you, Mr. Chairman, but I believe the topic's been addressed by the trial judges, and I have really nothing to add.
Okay, thank you.
Mr. Chairman.
Senator Nethercott.
Thank you. If I may address maybe a question to Chief Justice Davis. We heard yesterday testimony from the court about expenditures of funds, and we were asked to review a bill for court security and cameras for the counties to pay for, and approximately, I think, $6 million in fees raised to update some of the audio equipment within our courtrooms. And I'm frustrated with that information and the costs associated with some of those kind of infrastructure type needs in light of the topic of conversation we're having today and the tens of millions of dollars and that number continuing to increase exponentially when we look at how we're actually operating our criminal justice system and the decisions that we're making and the lack of data available to our judges in making these these sentencing decisions and determinations. We've heard go to DOC, they have some of that data, and I believe that DOC does have that data, and DOC is actually the only entity in the state that is tracking that data, and I don't believe that's being translated maybe back to the district court judges. So curious to hear if there's been any conversation from the court of reevaluating some of those financial priorities for access to data and information, so more empirical determinations can be made regarding appropriate decisions by our district court judges.
Mr. Chairman.
You're invited to come to the table, Mr. Chief Justice, if you'd like, and make sure the red light is showing.
I think it is.
Great.
Senator Nethercott, I apologize. I wasn't here yesterday. I was in Casper doing a judicial nominating commission proceeding. I can tell you generally that the hope I have, and I think it's a realistic one, is that we are gathering data consistently now as we've moved to an electronic case management system that we're able to mine to a certain extent. It was my understanding that perhaps that data was mined to some extent by CSG. And my hope, at least, is that we will be able to provide greater statistical information on a variety of topics. But I should probably defer to our court administrator or our IT people on that topic if you have any comments.
Chairman, Senator Nethercott, and that's accurate. We did provide the council state governments the data that we have, but because our case management system right now is not fully functional, we aren't able to collect all the information that DOC has, and the Chief Justice is correct that that our data and DOC's data, we actually don't share that data other than the actual proceedings and the pre-sentence reports, and that's correct.
Okay, thank you, Senator. Thank you, folks. So we've moved now past all the invited panelists, but we have a time for public discussion. And I know there are people here just out of the general public who'd like to comment on these topics. So raise your hand and we'll recognize you and get started with that. Mr. Smathers.
Judiciary Committee, I thank you for taking the time, the interim Judiciary Committee, taking time to listen to me. I'm a social work student at the University of Wyoming. We started this as a project, but we have gained passion and we have left the project realm of it and come to do it. And I'd like to share a story.
Could you state your name for the
Oh, yes.
staff,
Tyler
please?
Smathers.
Yes.
Sorry.
thank you.
Nervous up here, but these chairs are comfier. So, members of the Joint Judiciary Committee, I would like to share a story of reconciliation with you. There was a young promising boy that seemed to have the world at his hands. Soon this young teenager thought that he knew everything. I don't know if that sounds familiar to anyone, but he eventually got mixed up in drugs and alcohol, and his life soon began to spiral. He was in trouble so much he was kicked out of sports his senior year of high school. This only led to spiraling downward. He soon got to college where he still knew everything and still did drugs and alcohol to chase what he thought was normal, his normal. Little did he know that his biological makeup had deficits in which drugs and alcohol only covered the problem. Shortly into college, with failing grades and absences piling up, he had a mental break. He somehow thought he was invincible and became reckless. Only after being stopped by campus security did he get the help he truly needed. He was taken to the hospital and tested for drugs. The police were involved and found drugs in his dorm room. They decided that treatment was best, and that decision saved his life. I had a co-occurring disorder. And I was put into treatment at Wyoming Behavioral Institute in Casper. I believe I was put there because I had private insurance from my parents. I was put into treatment for under title. I won't quote it because I forget the title, but I received treatment, and the courts put it up to the psychiatrist to eval me and release me when it was time. Eventually, the psychiatrist discharged me, put me into my parents' not custody, but he told me that I had to move in with my parents if I was allowed to go home, which I believe is, for some people with treatment, is not an option. And so I got back into activities with friends, family, through this treatment of outpatient counseling, medicine, all these wraparound services that I think everyone's wanting to get, but this bill doesn't necessarily include. I got back into activities with friends, family, and church activities, and I would allude that there's many people that my cohort and I have talked to of the religious community that have seen problems like these with parolees and probationaries. And the reason I think I was so successful is that I got treatment right away. I got a bed, I got into WBI, and I think I have I'm from Casper, but I'm currently living in Bridger Valley, where my wife is a fourth grade teacher, and I was a previous fourth grade teacher, but decided to pursue the master's in social work. And there's a sense of community in Bridger Valley. In Mountain View, people wrap their arms around each other. If someone's in trouble, they help. And I think that's the real Wyoming sense of pride of helping their family, friends, and neighbors. And I just have a quote from Jason Bruff, and I'll just premise with this is I know not everyone in this room is religious, but I think Wyoming has a strong culture of faith and community. And so Jason Bruff states, forgiving those who may have caused our hard thing and reconciling ourselves to the will of God can be very difficult. It can hurt most when our hard thing is caused by a family member, a close friend, or even ourselves. As we face hard things in the Lord's way, may we lift up our heads and rejoice at this sacred opportunity to testify to the world what Wyoming really holds true. I added the last part. So I just wanted to share my testimony of how treatment, how lesser penalties, not punitive treatment, those types of things can really turn a life around. Made me a fourth grade teacher, had awesome relationships with the kids. It wasn't for me. I'm interested in this kind of work to help really advocate for those people who don't have a voice. And I just like to thank you for all you guys are doing to, and ladies, sorry, that's the guys term is just lingo. So I'd just like to thank all of you for the work that you guys have been doing to make this the best bill possible, and also get that treatment for the people that really need it, so that someday someone like me can be in the position that I am in now and not in the penitentiary. Thank you.
Thank you very much. And I think it is always very helpful when the committee hears from people, who are just out in the community being affected by this stuff. So thanks for what you had to say both yesterday and today. Committee, any questions? Senator Hicks?
Yeah, thank you, and appreciate your testimony. It takes a lot of courage. The question I have is this, we've got an article up here, and I don't know who presented it. I read it earlier this morning about the experiments in North Dakota and the role of faith-based organizations up there in their program. But would even with the treatment, would you characterize what role? I don't want to percentage or stuff, but
Okay.
it's one thing to get counseling, and it's another thing to have that support system. And I think that's what the North Dakota model. But how do those play off of each other? I mean, one's important, but is one sufficient to get you over the hump? And in your particular case, it sounded like it took more than just the treatment, that it also took that faith-based support from the community. But do you think there's enough? So the question is how important was that to have that other option? But do you think there's sufficient tools out there that within the faith-based community within the state of Wyoming?
Others?
Yes, I would think that yes, definitely both supplement and complement each other. In regards to Casper, there's a lot of faith-based organizations that try to do help and do those things in the community. There's a coalition of churches that my dad is a part of. There's the Catholic Church, the Lutherans, the Baptists, LDS Church, and in Bridger Valley, it's highly LDS populated. And so there's a lot of support, but I'm working in Bridger Valley right now with the Public of Health, Kim Profit and Kendra Safford, to try to make a coalition because I think the coalition between the community of the Wyoming Health, the mental health, behavioral health realm, and the faith-based community haven't made a unity, hasn't made quite a unity to make a coalition to help with substance abuse, behavioral health issues. And I think if we had people in each community trying to make that a stronger fit, that would help.
Thank you.
Does that answer?
Yeah. Thank you very much. I think we had another lady who wanted to speak to us. Welcome, and if you would please state your name and any affiliation you have.
My name is Anna Cryer, and I'm just a citizen with some concerns. Thanks, Chairman, Senators, Representatives, for allowing me to speak this morning. I'm wanting you to hear this story about my 21-year-old daughter, Madison Reekins. She is currently serving a 2.5-year sentence in our county jail for a second misdemeanor marijuana charge. She is in need of mental health treatment instead of jail. She has had some traumatic events in her short life. She was sexually abused from the ages of 12 to 14 by her stepfather, which has led to substance abuse, self-harm, and 2 suicide attempts to help her cope with this trauma. At age 17, barely, she gets her first charge for possession of marijuana, misdemeanor. Judge now charged her like an adult. 6 months with youth alternatives, $2,500 cash bond only. Her caseworker dies that they could not find her file. She relapsed. She was supposed to be released, but judge now orders her to take a UA and to come back. Sends her to the youth jail and puts her back on probation because she fails her UA. No offer of mental health or substance abuse counseling. At age 19, a misdemeanor marijuana charge. Judge now remembers her, brings up her minor record in court, gives her 1 year probation, no diversion program offered. No offer of mental health or substance abuse counseling. It takes her several months to come clean from her UAs. She tests dirty one time, tests clean, tests clean. She's not continuing to use drugs, it's the faulty test strips. In December, her childhood dog dies. She attempted suicide and relapsed. Failed a couple UAs and stopped going. At age 19, she gets a possession charge, DUI misdemeanor. On 4/20, she was pulled over for failure to signal. She had 3 warrants, spent 8 days in jail, and a $5,000 only cash bond. Judge now was enraged. My daughter was pregnant. She had a fetal miscarriage in jail. No medication, no offer of mental health help. Bills for the UA of alcohol, which was her NyQuil, and Adderall, which shows up as meth. She pleads out and wants to go to rehab, her choice. And then Laramie County Drug Court, Judge Now's choice, with an underlying 2.5-year sentence in county. She attends an elite rehab center, the Foundry, in Steamboat Springs, Colorado, for 60 days. She does incredibly well in the program, but her insurance won't cover another 30 days. In rehab, the therapy started to bring out the sexual abuse that she had repressed from the ages of 12 to 14 from her stepfather, resulting in her self-harming, her suicide attempts at age 14 and again at 19. Rehab had hoped that she would have a great aftercare program to continue to work on these issues. She came out of treatment ready to conquer the world. Stable on her psych meds, she entered Laramie County Drug Court with high hopes. Drug court in August. She got into drug court with the misdemeanor charge, not a felony. Judge now asked them to do a personal favor for her to accept her into the program. There was no addiction severity index done at the time when she entered the drug court, so they had no idea where she should truly be starting. She had to start at 0, even though she had just finished 60 days in elite rehab. She had to redo the same work that she did in rehab in Steamboat. She spent 10 months in IOP. There was conflicting treatment plans that from what she had learned in rehab. She had no time for AA or NA. She was only allowed to see Jim Nelson, a male therapist. She wasn't comfortable talking about anything with a man. She was seeing a female therapist, Mary Jane Schultz, which drug court told her that she wasn't allowed to see anymore, partially because she held drug court accountable. Drug court did have their favorites. A female member of drug court was not required to have a phone, but my daughter was required to have one. Another female drug court member was caught in the act of a sexual relationship with another drug court person, which was supposedly grounds for immediate termination from the program, and yet nothing happened to them. The same female member wasn't required to work or do community service. She got to be a stay-at-home mom, although she only had her kids 3 days a week. Yet my daughter was required to be a full-time student and work full-time. She was only allowed to hang out with other drug court people, which most of them were there for felony, hardcore drug crimes. She was required to be a full-time student, work full-time, attend group 9 hours per week, do daily drug, spice, alcohol testing, sometimes twice a day, weekly one-on-one meetings with Jim, meet with her probation officer, Mackenzie Walters, every week to do schedules. She had no time to work the program she learned in rehab. She had several minor violations and sanctions. She relapsed in February from a vape pen that she didn't know had THC in it. She took a hit. She told on herself. She relapsed again in April. She got her very first violation on the first night for curfew. She was placed on an ankle monitor for giving a fellow drug court person a ride home from group. She was put on a GPS monitor for having a boyfriend. She went to jail for not having a job every weekend until she got one, even though she was a full-time student. She was sanctioned for not paying drug court fees, even though they told her that would be okay until she got a job as long as it was paid off before she graduated the program. She was 1 minute late for court and spent 24 hours in jail. Other people were late on the same day and had recently relapsed, but nothing happened to them. She was 7 minutes late getting home from group. She received 30 hours of community service, even though she attended school full-time carrying a 3.8 GPA. She was sanctioned for leaving the house to go get food. She couldn't reach her probation officer. She was sanctioned for me having company at the house. She got fired from a job in which she was being sexually harassed by a boss who was a registered sex offender. No one would do anything to him, even though he was violating his probation. She was late every weekend due to the fact that she had to take a drug test. The drug testing center was only open right before her shift started and was closed right before her shift ended. She was sent to jail for losing that job. She got a violation for not defending her probation officer on Facebook for when a fellow drug court person posted something about her, and the probation officer was yelling at her in our home, and my mom and I heard the probation officer break confidentiality by using a drug court member's name. She maybe in total was without an ankle monitor for about 2 months. Her final violation was when she was at work and she forgot her phone at home. The PO came in at 4:30 wanting her to take a UA by 5. She was the only employee on duty and couldn't leave. She was on the phone with tech support when her probation officer arrived and she couldn't talk to her probation officer. Tech support answered and she turned away to take the call and the probation officer left. A few hours later, she came back and arrested her. PO officer, why couldn't she have brought the drug screening test in? She's done it before. She's brought mouth swabs to the house and done them there. They left the business unattended. She had taken drug, alcohol, spice test the day before, which was negative and clean, and she had to take one the following day as well. They suspected her of smoking spice, even though she tested negative and clean and would never smoke spice. For not having her phone with her when the PO called her and not leaving her work unattended to go take a drug test, they suspected her, and them suspecting her of smoking spice were the reason why they terminated her from the program. Members of the drug court team have testified against drug court people in the past for things that have happened during the program, which in some cases have gotten their kids taken away from them. People in drug court are not very trusting of the help the team is there for. How can you confide in a therapist if they are going to tell others and use it against you instead of helping you? In the last 12 years, or in the last year, 12 people have been terminated from drug court or opted out. It is about a 70% failure rate. Their model seems to be, let's see if we can, let's set these people up to fail. My daughter missed her high school graduation. They put her in jail a few days before. The principal from Central High came into the jail with her cap and gown and presented my daughter with her high school diploma to show how highly he thinks of her. They took photos of him presenting her diploma in jail. She had letters from her bosses about what a great person they feel she is and the unjust treatment that they have seen. Dr. Tom Kirk and Mary Jane Schultz both have wrote letters and did evaluations that she needs mental health treatment, not jail, for many things included but not limited to PTSD, sexual assault, father issues, substance abuse, self-harm, and suicide prevention. My daughter requested a reduction hearing so she could go to the Rose House. The Rose House is a great mental health facility with an underlying focus on substance abuse, which was referred to her by the Foundry. Judge Dow did not want to hear and says, of course she wants to go to treatment rather than jail. Who wouldn't? But no, she's going to serve her sentence. And if she chooses to seek treatment after jail, there's plenty of time for that, but I doubt she will. She got a felony sentence for a misdemeanor charge. People with 2 or 3 meth charges are serving less time. There's a person in drug court currently right now with a 6-year underlying sentence in our county jail if they don't succeed in the drug court program. No pre-sentence investigation was done prior to her sentencing. She has been denied her psych meds that were prescribed to her Seroquel and Neurontin, but yet there's a person in jail that's allowed their Seroquel. Every time she's gone to jail, she's had to go cold turkey off her psych meds. Has not been able to be stable since leaving rehab. She has been denied mental health and substance abuse help in jail. The deputies in the jail have been telling her she doesn't belong in here. Don't let this place break you. You're too smart. You have a level head. She wants to go to prison so she can get mental health help and be afforded an education. She gets no exercise, no educational opportunities. She should be in college. She wants to do pre-law. I wonder why. If she had gotten the mental health, substance abuse care after her first offense, they could have found out about her trauma and treated it. And there would have maybe been no repeat violations. She's locked down 21 hours a day. She only gets video visitation 2 times a week for 15 minutes. She's still trying to process being sexually abused from the ages of 12 to 14 by her stepfather with no mental health help. She has talked to detectives a few times about what happened to her, and they are not getting back to her about her being sexually assaulted as a child. She's being victimized again through the county jail and her sentencing, which she has been denied many things. Our county jail is not equipped to house people for long periods of time. If she would have been sent to prison, her time served would be considerably less. She would have a chance to start her education and to get mental health help that she needs. There are a lot of people that are currently sitting in our county jail for misdemeanor violations with no help for mental health, substance abuse, which is leading to the overcrowding in our jail. Yes, my daughter did break the law, and yes, she should be adequately punished. She has currently served 5 months and about 3 to 4 months with her sanctions from drug court, roughly 9 months in total, but still has 2 years in our county jail. She didn't get any credit for any of her sanctions, rehab, or time in drug court. The effects of no help with her sexual abuse, mental health, reasons for substance abuse, the injustice and unfairness of our justice system will have a significant negative impact on her for the rest of her life. It will take years of mental health treatment, substance abuse care for her to be able to overcome any of these traumatic events in her young life, for her to even to have somewhat of a normal life. Our system is broken and something needs to change. Thank you.
Thank you, Mr. Crowder. You've given us a lot to think about there, and thanks for taking the time to put that all together.
Thank you.
Committee, anybody have a response to that or a question?
Yes, Mr. Chairman.
Representative Pelkey.
I appreciate your testimony a great deal. Not only does it underscore some of the problems that we have in this state, but it underscores the disparity of treatment that we have around the state. Had she been arrested 50 miles to the west, drug court would have been a completely different experience. There are counties without drug courts. Sentences vary there as well, but it's amazing to hear the stories of how things are different around the state of Wyoming because of that. And I hope that everything works out for your daughter as soon as possible. I wish you luck.
Thank you.
Thank you. Someone else? Sure. I just ask that you make your comments as pointed as possible. We've got a lot yet to cover, but
yes, sir.
We'd like to hear at least a little from everybody. So,
my name is Jason Mittleiter. I was approached by the team to share my story. So,
please continue.
In 2006, I was a normal 22-year-old guy. I had adopted my younger sister and worked at Midnight Oilfield Services for 6 years. I was engaged to be married, was getting ready to buy a house, regular American story. I was injured at work really bad. I was going to need a series of back operations that would leave me disabled. I was prescribed massive amounts of pain medication over the next few years. First, I became physically dependent on them. Slowly, that turned into an addiction. Becoming addicted to pain medication was just the start. I started abusing my medication, running out early, and having to self-medicate. Self-medicating was detrimental to my life. I slowly lost everything to my addiction. My fiance left in 2009. This was also the year I started having trouble with the law. I developed an alcohol problem to coincide with my opiate addiction. I got a urinating in public ticket, and I got out of jail the day I got out of jail for public intox and a breach of peace. Both times I was arrested. While in jail for the public intox, I had to wait the weekend to see a judge. I began to get extremely sick from coming off all the substances I was barraging my system with. The sheriff's department did not know what to do. They called my doctor and called an ambulance. The hospital gave me a prescription for Percocet to take while I was in the jail. At this point, my addiction was more than anyone wanted to handle. I knew I was getting in too deep and I couldn't stop. Over the next few years, I would lose what little I had. I was arrested probably half a dozen times. Possession of a controlled substance, DUI, failure to pay my fines. I was now using methamphetamine regularly, getting my prescription from whatever doctor I could convince to give me one, then buying heroin when it ran out. Drinking daily, all day, no matter what. Alcohol was the easiest to find. I needed help. I went to the hospital to get it. They admitted me to the 5th floor psychiatric unit for 5 days. I thought that they would send me to treatment. They just released me back onto the street. I went a little while and tried again. They called the cops on me at the ER. I left before they got there so I wouldn't get arrested. I wanted help, but nothing was working. I became very bitter. In the winter of 2015-16, 2 of my very close friends overdosed and died on heroin that was going around town. I didn't want that to happen to me. I had overdosed a few times, but not enough to require medical attention. I was revived by a friend and went out about my business. In July of 2016, I was serious about getting help. If the hospital in Gillette wouldn't help me, I would go somewhere else. I got my mom to help me. We had to get me into a treatment program. I was staying in a motel and using enough to keep from getting sick, but seeking help. Treatment center said I needed an ASI. It was $180. It might as well have been $180,000. I was at rock bottom. I was broken emotionally, physically, and financially. I talked my mom into paying for the ASI. I thought that would be it. I would finally go to treatment. The counselor I talked to gave me a 4.0 rating. The treatment center said that that was too high. I would have to go to detox first. So I drove to Johnson County Hospital, an hour away in Buffalo, Wyoming. I had kind of went on a last party spree a few days before. They admitted me and said they would help. I was so relieved. I was scared. I didn't want to experience the withdrawal. I wouldn't wish that on my enemies. I had a lot of experience with withdrawal. I would try to quit, but by just not using, but I would get so sick. I would do anything to avoid getting that sick. I couldn't keep going. I was nothing. I weighed 145 pounds. I'm 225 today. They really wanted to help me in the hospital in Buffalo, Wyoming. After taking blood and urine, they realized how bad off I really was, though. They put me in an ambulance and sent me to Wyoming Behavioral Health in Casper, Wyoming. I was there for 5 days. They gave me opiate pain medication while I was in Wyoming Behavioral Health. After the detox center didn't want to deal with my detox. It was crazy. I was just glad to finally be getting some kind of help. After the 5th day, I was called into an office and told I would need to call someone to come and pick me up. I was confused. Why wasn't I going to a treatment facility? They said I would have to go home and wait for a bed date. I was a lot of emotions at once. Disappointed, angry, frustrated, hopeless. I called a friend that would come and get me, and I was high again before I left the parking lot. I was dead inside. I felt like God didn't want me to get sober. I didn't know what else to do. All of that work for nothing. Nobody cared about helping me. I was just a problem. The doctor at Wyoming Behavioral Health gave me a prescription for oxycodone as I left the building even. I just laughed. I was never going to get treatment. 2 months later, on November 18th, I was arrested for felony aggravated assault with a deadly weapon. I was in jail 104 days. They gave me Percocet while I was in jail for that 104 days. It was supposed to be an opiate-free facility, but I guess not for me. I was given a plea offer that I could not refuse. It would be 2 to 4 years in prison, suspended with 3 years of probation. I felt like I could have beat the charge in court, but in order to fight it, I would have to recover from a surgery in jail, which I could not do. Nobody would bail me out of jail so I could fight these charges. The plea was my only real option. The prosecution knew this, and I decided to take the deal. I would be out on bond until sentencing. While out on bond, I continued to use. I underwent another back fusion on April 17th, 2017. I went to sentencing on June 27th. While at court, I was given a breathalyzer. I blew hot and had to spend the night in jail. On June 28th, I was sentenced to 4 to 6 years with 5 years probation and mandatory inpatient treatment. The judge increased the sentence because of my drug problem. I was not happy that I was now going to be a felon. I was excited, though. Finally, I was going to get the help I had been trying to get for years. Ordered by a judge, I spent the next 5 months in county jail awaiting a bed date. On December 18th, 2017, I was released with the condition I show up at treatment here in Cheyenne, Wyoming. I did. While at treatment, I was put on the Suboxone medicated treatment program. It worked great. I was a model patient at TRP. I stayed longer than I had to. I knew I needed to stay longer. I graduated June 6, 2018. While in treatment, I took every class they had to offer: MRT, nutrition, anger management, and others. Today, I am 1 year, 4 months, and 6 days sober. I'm completing my first semester of college with a 4.0 GPA. I'm on disability because of my injury and active in Drug Addicts Anonymous. Drug Addicts Anonymous has been instrumental in my recovery. I do need to mention that I do not represent them here today, though. They have no opinion on outside matters. But I do have an excellent sponsor who has guided me through this. I truly am sober still with no relapses. I am enjoying my life. I really wish treatment was easier to get. I know a lot of people who would love to quit, but when you're not taken seriously or laughed at or the police are called on you at a hospital, you give up. You stop seeking help. I believe wholeheartedly that my friends would still be alive today if help was easier to get. If I would have gotten help, I wouldn't be a felon right now. I hope sharing my story will help others get help easier. I am not proud of the things I have shared here today. I'm not bragging, but if I don't be honest about it, then the same thing will just keep happening. Thank you for letting me share.
Thank you, Jason. Glad you got it turned around. We wish you the best. Committee, Senator Hicks.
Thank you again. I know it takes a lot of courage to come and do that, but the question I have for you specifically, do you think based on your experiences and where you're at in life that you could help people navigate that system and mentor those people? Because it's only people like yourself that have been through it to really understand it. So is that something, you've obviously expressed a desire to continue moving forward, but do you think that you would actually be able to help people in your same situation?
Yes, I do. I think I could. I'm active in DAA. I go to a 12-step Bible study program. So I'm sort of active in the recovery community. I need to continue my education so that I can become more useful in those areas, but that's definitely what I want to go into. I want to help people with injuries. I had a lot of trouble with my injury, with getting paperwork filed, you know, and so I was going broke and just everything was getting to be so much to handle. And there was really no help for me out there for that. And plus, I had this thing I had to disguise. You know, I didn't want nobody to find out that I was a drug addict. So I really do want to help people like that. And that's what I'm looking to do with the rest of my life. And I'm just glad to be sober here today. And I hope my story helps.
Thank you.
Okay. Anyone else? All right, sir. Thank you. Come on up.
Yeah. Good morning, Mr. Chairman, committee members. My name is John Olive. I am I wear a lot of hats. Presently, I am a sentencing mitigation specialist, but I have worked as a state probation agent for Department of Corrections. I have retired after 25 years as a federal probation officer. And I also facilitate a Bible-based 12-step study, which Mr. Mitleiter actually attends. So I wear a lot of different hats, and my comments today really are to address the issue of substance abuse as it relates to the criminal justice population. Steve Lindley had actually provided me with some statistics earlier this year, and I don't have the exact numbers off the top of my head, but somewhere between 80 to 90% of those who were incarcerated in the state of Wyoming are in need of substance abuse treatment at a significant level, whether residential or intensive outpatient. And probably less than half of those are going to be able to actually get into an ITU and complete it while they're in their term of incarceration. And that to me seems like being somewhat irresponsible with state revenue, because if we don't address the fundamental reason why most individuals are incarcerated, then we're not really being effective in trying to ensure that they don't come back into the system. And all of us are very concerned about recidivism. And so, you know, I would be a strong advocate for shorter sentences in conjunction with a higher percentage of those individuals being able to get into substance abuse treatment. whether that's while they're incarcerated or ideally, I guess, before they get to that point. Because that's really where we can make the most bang for our buck, is at the treatment level. And it's based on experience of working with literally thousands of offenders over the last several decades, since 1989. So those are some of my comments. I deal with so many sentencing issues that I have to admit that, and one of the questions earlier, debating about how do we fashion the probation terms under 713-301, if I may comment just briefly on that as well. What struck me is that you could have a presumptive range of, say, 42 to 60 months or 24 to 48 months, and then allow the judges to depart to up to whatever you want to say, maybe the statutory maximum, with a finding of clear and convincing evidence, so that you have a presumptive range that requires no special findings. But if the court wants to go above or even below, they can do so with a clear and convincing standard that's put on the record that can be evaluated. Just to throw that out there. That's how my mind works. But basically, the reason I'm here today is to address the interplay between incarceration, corrections, and treatment. And I really appreciate you listening to my comments, and I'd be more than happy to answer any questions that you have.
Questions for Mr. Olive? Senator Hicks.
Similar question to the first witness, but in your experiences with all the parole, and obviously it appears that you're also involved with not only from the substance abuse side, but on the faith-based side. So I'd like to get your perspective as if there's a marriage there that has a higher level of success or not.
Well, okay.
Mr. Olive.
So it's an excellent question. Thank you, Chairman and Senator Hicks. The critical goal is to take an irresponsible, selfish, self-centered individual and turn them into a responsible member of their community. Okay, and that is a handful. All right. So as a person of faith myself, what is the most powerful motivating tool for any human being is to have an internal compass. All right, and there is no more effective way that I have found, either in my life or anybody else's life, than to have an individual guided and motivated by their own internal compass of what is right and wrong, and attempting to be faithful to those ideals and ultimately to God himself. And when you can make that transition in a person's life, you pretty much have a built-in internal probation officer that goes with them for the rest of their lives. And so that's what I attempt to accomplish when I'm working with individuals in a Bible-based 12-step program. But that doesn't work for everybody. Not everybody has a motivation like that. And so for them, they're more externally based in terms of how do you motivate them, and that takes a different framework. But for those who will embrace that particular approach, it is incredibly effective. And I could give you chapter and verse of individuals who have been absolutely, totally transformed by their relationship with God and going forward as a responsible human being.
Thank you.
Anything else? Representative Stitt?
Mr. Chairman, thank you very much for your sort of assistance with our potential bill drafting. I wanted to ask you again about this presumptive range idea. You said subject to a showing of clear and convincing evidence, and I just wanted you to complete that thought if you could. How would you complete the sentence? Say maximum range of 42 months, subject to a showing by clear and convincing evidence of what? Of blank. What would need to be shown?
Mr. Olive?
Yes, sir. I apologize. Chair and representative side.
Yes.
So essentially, the answer would be that based on clear and convincing evidence of a need for a term of probation that was outside of that range, based on whatever factors the judge would find. Maybe you could just enumerate them in the statute, or you could leave it up to the judge to put those on the record that could be reviewed by an appellate court. But in some way, the court would need to justify on the record by clear and convincing evidence any term of probation under 713-301 that was outside of your presumptive range.
Mr. Chairman, just to follow up on that, and just so that it's not, so that it has some standards to it, any suggestions? Because if it just says clear and convincing evidence that I think it's right, that's hard to review, right? Any thoughts on showing that it's necessary to, say, prevent probable recidivist behavior? What would you say?
You could, again,
Sure.
Chair and Representative Stith, apologize for my discomfort and never testified in a situation like this.
You're doing fine.
The protocol is a little unusual to me. But based on things like need to protect the community, maybe based on particular type of offense, the defendant's prior record, and some set of criteria that you could put in there that would help guide the judicial discretion.
Okay. Anything else? All right. Thank you for your appearance. Anyone else? Mr. Craig?
Thank you, Chairman, committee members. My name is Frank Craig. I am a state director for Gateway Foundation, and we currently have a contract with the Department of Corrections to provide the substance use disorder treatment institutionally. I did commend the committee on taking a look at the judiciary reforms. It's not anything that's new for other states that have looked at it or are looking at it or need to look at it, and it's certainly an issue that requires quite a bit of looking into. It affects a lot of different areas. You're spending a lot of money, and you want to make sure you get the bang for your buck. That being said, with results, how effective that is. But when you look at things, and I've been very pleased with some of the testimony that I've heard yesterday and today, in particular concerns about how to go about doing this effectively. And my piece of the puzzle and my concern, and I'll use the term infrastructure as Senator Nethercott used earlier, but in the sense of professional services and providers, that we do ensure that there are necessary qualified people to do what the bills are intending. In other words, to expand or sometimes create some new services to be able to utilize in a deferment or trying to minimize people coming into the system. I'm working with some other legislative members in the Joint Committee for Labor, Health, and Social Services, and one of those issues that could be impacting what you're attempting to accomplish with these bills is ensuring that in Wyoming that we do have the necessary qualified people to provide, in particular, substance use disorder treatment. That's very challenging currently. I have 11 clinical positions that I need to fill, and I can't find people to do it. So we're working to try to maybe amend some statutes or working with the licensure board to effect positive rule changes so that we can all come together and make this mission happen. Thank you.
Thank you, Mr. Craig. Any questions for him? Representative Pelkey.
Thank you. Thank you, Mr. Chairman. You said you have 11 unfilled positions. Out of how many is that?
Mr. Chairman, currently we hold residential treatment at the Women's Center, at the Wyoming Medium Correctional Institute, at the Newcastle Boot Camp. Then we were able to bring back outpatient services that were cut from previous budget years. And I do appreciate that, by the way, that offered 2 additional staff at all 5 of those facilities, and then I have an additional 5 vacancies with the current existing contracts.
Thank you.
Yes, Senator Anselmi Dalton.
Thank you, Chairman. And Mr. Craig, thanks for your testimony. What licensure barriers are you experiencing quickly? And I'm hopefully they're addressing them maybe in labor health. And if they are, that's even better. But I'm just curious because obviously we need these people to be out there.
Mr. Craig.
Mr. Chairman, yes, Senator. Most of these positions would fall under a bachelor level certification. That's the CAP. That's a certified addiction professional. Interesting, in Wyoming, there's not an in-state institution where you can go and walk across the stage with such a degree to fulfill the requirements of the board rules to be able to apply and start practicing. Individuals have to go and gain significantly more coursework at their expense before the certification requirements could be met. Nationally, across many other states, just holding, for example, a bachelor's degree in psychology would be sufficient enough. And most certification boards do have built into their rules sort of a career path to be able to start at point A and then work towards increasing the skill and knowledge level that's necessary and that meets national standards.
Okay. Anything else? Well, thanks for the heads up. We'll be looking for that legislation in January out of labor and health. Someone else? Please.
Mr. Chairman, members of the committee, my name is Paul Demple. I am the CEO of Northern Wyoming Mental Health Center. Excuse me. I'm also a member of WAMSAC, the Wyoming Association for Mental Health and Substance Abuse Centers. We're the largest provider of mental health and substance abuse programs in the state, including residential and IOP, certain intensive outpatient services, and across mental health and substance abuse. What I want to say is I really don't have any thing regarding specifics on the bills that are before the committee. What I want to say is WAMSAC is already providing a lot of services to this particular population and plans to continue to do that and work with Judiciary and anybody else to shore up our services within the communities in terms of the offenders and trying to get services as quickly as possible. Most, if you look at some of the CSG data, when they did some overlap with the Department of Health clients, which is our clients, and the Department of Corrections clients, there is a delay on people getting into treatment. The delay we have, with the exception of residential, because there is delay there, in terms of getting an outpatient, you can generally get in pretty quickly. The delay may come from from the probation side or the judicial side of getting that person in quickly. Not always, but there may be some things that could be done there to expedite when it's a person with a substance abuse issue, much more quickly getting into our treatment system. What I will say about the previous testimony in terms of licensure, the licensure board has done some tweaking on some license issues. Currently, there's not a big barrier in the state of Wyoming. None of the mental health centers and substance abuse centers have this huge wait for people to get in because of licensure laws. Our problem is, like every other industry, trying to get people in general back to Wyoming. But I look forward to the mental health professions licensure rule changes. That's before Labor, Health, Social Services next week. And with that, I'll just close and say WAMSAC is here at the table and ready to step in and help any way we can.
Committee, any questions for Mr. Demple? Right, seeing none. Thanks for being here.
You bet.
Okay, Ms. Muir.
Good morning, Mr. Chairman, committee members. My name's Tara Muir. I'm the legal director with the Wyoming Coalition Against Domestic Violence and Sexual Assault. I appreciate that this committee is working so hard on criminal justice reform, and we're here to support this effort in any way we can. Just a couple of items that we'd like to comment on. Hearing from the Council of State Governments and all the research they did, wonderful. Data is the key. Empirical evidence can't be that alone. We have to hear the stories of the people who are most impacted. We have to do both. But the data piece must be clarified is whether it's the Council of State Governments looking at our data or our own systems. And that's just not the Department of Corrections responsibility. It's the court system, it's law enforcement, is really getting clarity on what is a violent offense and get numbers for those. If there's co-occurring substance abuse or mental health issues, being clear what that percentage is. So we're not lumping everybody in and continuing the confusion that I think is surrounding some of these discussions. Who is a domestic violence charge? What is nonviolent? Are these just drug offenses versus violence against the community or people? I would suggest that when we're doing data, and if we can amend these bills, let's look at it by gender and by race. So we look at equity. Treatment for men is very different than treatment for women, whether that's mental health or substance abuse. You just heard from a mom about how important it was that there be gender-specific treatment for the sexual abuse her daughter had. And you all did incredible work last year on domestic violence bills. If we do not have a criminal justice system that will believe survivors and go find out what happened to this young woman at the hands of her stepfather, we're delaying and making them felons, as you just heard. There's a couple of tiny pieces I'll just direct your attention to. It looks like in the 230 version, page 4, lines through 3, specifically on line 3, it looks like we do talk about the needs of the victim. It would be great to add that into 217. Also the same page 4 only talks about the risk posed by the defendant to the community. I think it's best practices across this country, and this goes to lumping all these cases kind of into one big puddle, that we very specifically look at the risk of reoffense against a victim in any of our criminal justice system work we're doing. I wanted to wait to speak till I heard everyone else speak, so I didn't say anything in addition, so give me a minute here. What was most surprising to me when I first landed in Wyoming, and then I'll probably be done, is looking at, and I so appreciated the input of all the judges and how hard they work to get these sentences right. But there is a lot of confusion in this is version 231 bill. When we talk about these 301s, allowing first-time violent offenders to also be lumped in with every other low-level crime. I think there are some first-time offenders, particularly in the domestic violence and sexual assault world, that shouldn't even be given that opportunity. There should be a record that they did offend, but they too should be subject to a lot of the things you're working on, getting the treatment, getting the help that they need. So I don't know if there's a way to be more clear that DUIs belong under 1037, which is page 4 of 231, that there's drug and alcohol treatment there, and keeping our 301 section all about violent offenders. I'm still learning how this whole criminal justice system works in Wyoming, but from kind of new eyes on the system, I think that's where some of our confusion lies. And I'll just end with what we heard in Laramie back in September, again from the Council of State Governments. They mentioned briefly, and I think it would help all our criminal statutes, and probably not for next year, but do we devise some system that says this is a class 4 felony, this is a class 3 felony, here's what the penalties are, and then we can look at our whole criminal justice set of laws and make sure we're comparing apples to apples. Do you get a tougher sentence when you key a car and have more than $5,000 worth of damage versus when you sexually assault a child? And look at all those crimes so that our data belongs to how serious the crime is. It's a little off topic, but I think it's central in, if we want empirical data, that we really have to get into the weeds and be very specific with that data. Thank you for letting me be between you and lunch.
Committee, any questions? All right, I don't see any. Thank you. Okay, anyone else from the public at large? I don't see anyone. So I will close a public comment, though, as we mentioned yesterday, as the co-chairman mentioned, that when we get into working the bills this afternoon, we may call on some of you, if the bill is really in your court and you may have some additional input for us, we may lean on you again. So, Mr. Pelka, from the Council of State Governments Criminal Justice Center, and he's been with us all interim long. And we want to make time for you and realize you may not quite get done by lunch. So just start in and do what you need to do, and we'll go from there. Good to see you again.
Great to see you too, Mr. Chairman, and great to see the members of the Joint Judiciary Committee. My name is Mark Pelka, and it's been a real pleasure working on this journey with you all over the last several months as part of Wyoming's Justice Reinvestment approach. And you might remember a larger team represented last time. It's nothing to do, no commentary on Wyoming's hospitality. In fact, we love the state, and they'd all like to be here. We just had to make the call about who could cover some of the key elements back in the office and who could be on site here. So we will bring back stories of how we need all as a team to take a try of chug water chili, which Jen and I learned about the other day. So as part of our culinary experiences around Wyoming, we did wow a lot of our coworkers back in the office, because after the September Joint Judiciary Committee meeting, we had for the very first time Rocky Mountain oysters. So they were very interested in that. But I'm not here to talk food. I'm here to talk about Justice Reinvestment approach and introduce my coworker, Jen Casella, who I'm realizing does not have any proximity to a microphone. I don't know if you want to consider swinging over here. While you're swinging over, I'll mention that Jen is a national expert in a variety of criminal justice policy areas, and she has been heading up the work going on through Justice Reinvestment as part of the probation parole analysis, the community-based program analysis, and has been a vital member of the team. And she works in a variety of states during the implementation of Justice Reinvestment. And so she sees a lot of the work that happens after the policies have been enacted and implementation is happening. We submitted several materials to the committee, and I heard the good Senator Hicks inquire about who provided the WyoFile article. So I should mention what we provided to you and hope that these all can be useful written resources. The first is the November 15-16 committee presentation. And this is on the screen right now, and it should be 3-hole punched and in your packets. Item number 2 is what we're calling issue briefs. We attempted to review the bill drafts after they were submitted to the public and summarized them. You'll go from in numerical order, increasing order from Bill Draft 217 to Bill Draft 231. It's our kind of policy review of that material and our effort to get our kind of grips on how it connects to the data analysis and the policy work that was done. The third item we shared is a piece from the WyoFile. Andrew Graham's work on North Dakota may hold key to Wyoming's prison woes in cases of use. Impressive that WyoFile sent Andrew to North Dakota to visit with a variety of people involved in the implementation of their free through recovery investment into community substance use mental health treatment. Incidentally, I worked in North Dakota last year, so I was on site a great deal during the analysis and policy development. I could probably speak to questions about North Dakota and its reinvestment. That would be helpful. Finally, we shut a lot of trees to come in front of you today. This is a response memo to Brian. I'm come so casual, the brilliant attorneys and also I've forgotten full name, Brian Fuller, his memo on the constitutional issues involving Bill Draft 230. My coworker, Carl Reynolds, is our senior legal policy advisor. He used to be the court director for the state of Texas, similar to Lily Sharp here, and he reviewed some of the questions and tried to do some case law inquiry. I've read through it. I've talked to Carl. I want to be a resource to you on those questions. I'm not anywhere near approaching the legal expertise that your LSO attorneys have or my coworker Carl has, but we wanted to make sure that we were a resource to you through that. We recognize that I had to adapt to the order of the meetings, and I wanted to begin by just sharing what a privilege it was for me to sit in the audience this last day or so and listen to the input from stakeholders in your criminal justice system. I'm honored to be sitting at the same table as people who had the strength and courage to share their personal story, speak a lot in data. I'm always reminded by the people whose lives are affected by the criminal justice system, and I found their testimony in the audience compelling, heart-wrenching, and inspiring. Wanted to share, sort of zoom out to the big picture if I could, with just a kind of example of what the big picture holds. We wanted to talk about 3 challenges facing Wyoming. The first is increase in drug-related offenses and case filings, contributing to an increase in the volume of people entering the criminal justice system with a variety of drug offenses. And there are people convicted of trafficking, manufacturing, people involved in the harmful distribution of drugs and other illegal materials. And those people are probably winding up in your prison or in the federal system. There are also people coming in there with substance use disorders, mental health needs, co-occurring needs, and it's creating strain for both your community behavioral health system response and your criminal justice system responses. And number 2, the prison population has increased by 21% in the last 10 years, putting you at full capacity and leading to use of out-of-state contract beds for about 80 inmates. And there you have a forecast of growth of 9%. A part resulting from growth in prison systems is the shifting of resources from the community to the facilities to accommodate the growing costs of corrections. It can be hard for states to invest in the supervision and the programming that can avoid the use of a prison and lower recidivism. And the third challenge, and where perhaps that's bearing out, is in the increase in the number of people entering prison after a probation parole revocation. 54% of prison admissions in 2017 were people revoked from probation and parole, and that number is up by about a quarter over the last 4 years. You have a lot of assets, which you've heard about from the people who came in front of you today and yesterday. You heard from sheriffs dedicated in law enforcement, stressing the importance of treatment, judges reaching for options. You heard about community behavioral health treatment providers that want to work with this population. You heard about victim advocates trying to connect victims to services and supports to help recover. You heard from probation, parole, prison, and so many more about the work they want to do. And this effort today is provide a plan to you all through these bill drafts you have in front of you. And that's your real asset, that you've been studying this issue during the interim. You authorized 5 bills for drafting. They're in front of you, and you're doing the hard work and working the bills while you're in this interim period to tackle it. And I think that gives you a lot of hope, and I hope that gives you a number of options as you head into the regular session beginning in January for how to tackle these challenges before you. And the cost figure is there. It's on slide 11. The cost figure is awaiting you if nothing is done. And I think there will be a section coming up in the presentation later on that expresses the opportunity in front of you to set a goal for recidivism reduction. We've estimated the impacts of achieving a 25% reduction in recidivism over the next 5 years. Recidivism measured as admission to prison for a probation parole revocation, reduction in length of stay, that will avoid the use of contract beds and enable you to not only avoid that cost and have money that would not go to to contracting for prison beds, but money that can be moved into addressing what I think has been a consistent theme, the importance of swift and high quality community behavioral health treatment, substance use mental health treatment. I'm trying to make sure I speed this up. We don't quite have the day you gave us in September, and I know you are facing a busy afternoon of work. I will, if it's okay with you, move more quickly through the slides than I was originally intending. The materials are all in front of you for further review. I just want to be mindful and respectful of your time. I'd like, please, to cover Section 2 regarding updated substance use and mental health analysis. I think it provides you with some new insights that very few states have concerning the overlap between your community mental health and substance abuse centers and your probation parole population. Number 2, I'd like to share the overall system challenges and some impact estimates for tackling that, and end with the kind of bill drafts and ways we can connect to the bigger picture. So I mentioned that to kind of zoom out and then home in. I've went in full respect to the chairs, will be guided by you all. If you'd like me to cut to the chase or move to the end, I respect the work you're doing and want to be a resource. We've assisted, this is on slide number 13. CSU Justice Center staff have assisted about 28 states in using the Justice Reinvestment approach. And one other state we could document enabled this type of analysis. It was North Carolina. And we are excited about this being groundbreaking, illuminating information, especially with the review of what are the available infrastructure in Wyoming for delivering effective community mental health and substance use services to people in the criminal justice system. With the hard work of the Department of Health, led by Franz Fuchs and Carol Day and Chris and Stefan, under the support of the director for participating in this analysis, with the Department of Corrections, Steve Lindley and Director Lampert, probation parole data over 4 years. Anyone who was put on probation or parole actively from 2013 to 2017 was matched with anyone who accessed a service inside of any of Wyoming's 18 community mental health and substance use centers around the state. And the slides that will come will show some really illuminating information about what was borne out from that connection. The limitations to the study involve that this is speaking about correlation, association. We were unable to control for all the variety of variables that would allow us to speak with causation, that if you do this, you will see that, or because of this happened, this occurred. So there are limitations in that respect, but what's come out of this is really quite extraordinary. If you look at the second row here, you will see that when we matched up anyone on probation or parole actively over that 4-year period who had a flag of some mental health or substance use need and matched it with anyone who accessed a service in any of Wyoming's community mental health and substance use centers, 57% of probationers or parolees showed up at some point. They make up about 10% of the people accessing a service in the mental health centers, but you can see that there is a large volume of people within the probation parole supervision arena who have access to service in one of the centers. There are some interesting variations across the state. One thing that was really intriguing is that in the lower right-hand corner of the slide, there are variations in what percent of probationers and parolees with mental health or substance use flags appeared in the centers. If we break here the state of Wyoming up into its various probation parole districts, and 80% of probationers and parolees with a mental health or substance use flag accessed a mental health service or more in the 3rd district, which is roughly around Sweetwater. And the number is lower in the northeastern part of the state for District 9, where 38% accessed. So you can see sort of a 57%, more than half, almost 2/3 of probationers or parolees access a service inside one of those centers. And that's a real asset for Wyoming. Those centers are open access. Those centers operate a sliding fee scale. And I met with virtually all of the directors of the centers, or my coworkers have, and there is a level of sophistication and awareness about working with people in the criminal justice system and a desire to promote better and better results for that population. So mentioning again the 57% of probationers or parolees accessing a service, the percentage of women with a mental health or substance use flag accessing a center is higher. It's actually 64%, suggesting that, and the research indicating that women in the criminal justice system tend to have more history of trauma, greater likelihood of involvement with substance use or other mental health needs. And so that was an interesting part that stood out too. But now you have a sense now of kind of what your landscape looks like. And I think in states that are grappling with how to connect people on probation and parole with treatment in the community, the impression can sometimes be we need to build up or rely entirely on the correction system to create these access points. You actually, through these centers, have resources that people are accessing in the community for addressing substance use and mental health needs. There are some challenges, and it identifies some areas through policy and budget through this approach that you can enhance the access that people have. And now I'm turning to slide 19, the slide that comes immediately afterwards. And we looked at the issue of how long after the supervision term starts, does that person wind up in one of your centers? And we all know how quickly relapse can occur and how important swift connections to treatment really are. And we found that 54% of probationers and parolees with the flag accessing a center came after 1 month had already passed. Only about 26% accessed that service within a week of beginning their supervision term, and another 19% within the month. So that could identify some barriers that exist for creating a continuity of care of people leaving prison, returning to the community, and entering a center. It could indicate some challenges involving care coordination between probation, parole, and the centers. When I talk to the centers, they emphasize the importance of the open access care model, that people coming in especially during open office hours, should be able to come in and receive an appointment. The challenges we know in a large rural state of people actually getting a ride to the centers, or making the appointment as soon as possible, or handling all the variety of needs that people have to fulfill as their conditions of supervision. I had mentioned that the percentage of people, this is on slide number 20, percentage of people who are on probation or parole that comprise the total center population is about 10%, about 1 in 10. But people on probation or parole who access that service consumed a greater cost of that service while they were in the center. People on probation and parole accessing substance use outpatient or substance use residential consumed 50% more than of the center's services than their numbers of so they're overrepresented in consumption of services than their makeup of the population within the centers. So for a state looking at ways to get a better return on your investment for your mental health and substance use services, this is a small part of your total population that's consuming a disproportionate share of services in the community. So perhaps front-loading access to the centers earlier on in the term before a decompensation or other relapse can occur could help to avoid some of the cost. Perhaps coordination with probation and parole can help to avoid the greater consumption of the cost. But this shows that for the Department of Health, and we are so important that they're here at the table providing data, reacting and guiding, and there's an endless push I'm hearing from staff in Department of Health for continuing the work, that this is an initial analysis and there's much more to come. That really heartens me because it shows that corrections and health and the center directors at the state level want to work on this and really maximize or enhance your existing structure for connecting people to community mental health and substance use services. The following slide, on slide number 21, you see 2 lines going down. This is a credit to the sophisticated analysis that Franz and coworkers at the Department of Health carried out. This compares survival analysis. The definition of success was when you're on probation and parole, longer stays in the community, meaning you didn't get revoked and wind up in prison. And you can see that the line below involves those who did not access services. That line shows that a smaller percentage of people on supervision who did not access services in the center and needed services failed and wound up in prison. The line is higher, showing greater success for people who need the services and got them. They stayed out of prison. They spent an average of 305 extra days in the community. And based on an initial cost-benefit analysis, the cost of connecting people to services, especially for high risk, high need people, exceeds the cost of prison days. So it shows the fact that these are two different systems, one criminal justice, one behavioral health, that are essential for promoting success of people on supervision, remaining crime-free, and helping to recover from their substance use or mental health disorder. These are our key takeaways on slide 23. And this is the kind of things that we were able to come across in our very initial analysis. And I think a lot of the work that we've assisted Wyoming with, when it's most successful, is identifies more areas for people in your state to delve into. And I think that's what I heard in meeting with the WAMSAC directors. They wanted to know why the percentages of people in need of treatment on probation and parole was lower in some parts of the state than others. Corrections wants to know how they can prioritize the highest risk, highest need people first and foremost. And so these are the 4 takeaways that we took. That first of all, that 57% of people on probation and parole accessing a service is key, because now it shows you where they are showing up if they need it. Rates of supervision with a indicator of need for treatment and accessing a service varies across the state. You have some areas where it's 66, 80%, others where it's 38%. And that's an important question to note, because centers are a key area for people on supervision to access services, but they may access it elsewhere, emergency room, private insurer, other areas. But now you know there is a large volume of people who are showing up in the centers and accessing it. We know that the results for high-risk individuals in need of treatment is higher than people who are low risk. That is very consistent with national analysis involving how you prioritize need for treatment, risk of reoffense, and shift your resources to the highest risk, highest need. Mental health treatment is mostly delivered in the community on an outpatient basis through the centers, which helps the results to be less expensive and a better cost ratio. It's interesting to note that mental health is not a criminogenic need. It's not associated with recidivism in the way that substance use is or antisocial thinking is, but it is a key responsivity factor. It's very hard to complete a condition of supervision, a treatment plan, if you have unaddressed mental illness. This is powerful analysis, and I sped it up because I really wanted to share it, and I know your time is short. I feel that this analysis has really helped to push forward clarity and information around how Wyoming could best reinvest a portion of avoided costs into enhancing access to community substance use and mental health treatment. These are 3 goals that emerged from this analysis: connecting people on supervision with substance use mental health needs more swiftly, prioritizing people at a high risk to fail on supervision who have a need for treatment, and tailoring the strategies to meet the local needs across Wyoming. And what we've come across is that where you are in Wyoming, as Representative Pelkey mentioned earlier, where you are in Wyoming can say a lot about the types of services that are available. You may be able to get residential inpatient in some areas, but not in others. Some areas may struggle with lack of coordination between probation, parole, and treatment centers. Others we've heard have it done quite pat. Some areas have peer support specialists who can really help people avoiding relapse. And some areas have struggles getting people from where they live to the centers. So there's a chance you have now here that you've isolated challenges. You've become more aware, you've identified more clearly the assets available, and you can set some goals, some guardrails around which you can prioritize any investments in the years to come into this critical area of community substance use and mental health treatment. We hope to quickly review the key challenges that are addressed in the policy options and ultimately the bill drafts. The three challenges is on slide 26 that we've drawn out involves the insufficient supervision and programming for people who are at the highest risk of failing on supervision. You know, because of your COMPASS risk assessment, the rate of failure for someone on low risk, someone's assessed as low risk, is 2 to 3 times less than people who are at a high risk of recidivism. What the research shows is that people who are high risk because they have specific needs, that have to be addressed in order for you to see impacts on recidivism. They're also in need of treatment and programming and are more likely to have complex needs. Putting money into low-risk people, supervision to low-risk people, really pulls resources away from your high-risk population and actually could cause increases in recidivism by involving them more deeply in the criminal justice system. This is a slide that we've been talking a lot about, the fact that most recidivism occurs within 3 years. Actually, 84% of recidivism from probation occurs in the first 3 years, yet 60% of probation terms are 3 years or longer. So there's a lot that's expected of a probation and parole supervision term. And we've heard a lot about them in the last couple of days, from fulfillment of legal financial obligations, from providing an adequate representation of the seriousness of the offense, from complying with a treatment plan, from the key priority question of when do most people fail and how do we move our available resources to align with that likelihood of failure. That's what led to the policy option to front load probation and resources at the early part of the term.
Mr. Pelka?
Yes.
The co-chairman has a question.
Yes.
Thank you, sir. Thank you, Coach, Mr. Chairman. Mark, when we talk about that scale, and it's an amazing scale, have you put a dollar figure to the cost savings that are available in those in years 4 and 5? So that one of the questions that came up is, are we really putting much money into those years of supervision? Is there significant resources by changing that formula, narrowing that window? What's the amount of money that comes available to come back and put into years 1 and 2?
Mr. Chairman and Senator Christensen, we did not estimate a cost impact for this policy option. In a way, it enhances your existing resources. You have a growing probation and parole population, and this is a way of helping to avoid the costs that would result to accommodate that increase. So the goal here is your probation parole officers are no longer supervising those higher end people. You're not laying off officers. You're not stopping the work you're doing. You're just moving it earlier on in the term. So the same amount of work stretched out then moves in. So it might be a micro reinvestment as opposed to cost savings.
Did the
continue
when you visited with those people, probation, parole, they didn't give you any kind of a number on the amount of resources they were spending or hours, maybe it's in hours, in the 4th and 5th year that would then be available to put back into the early years? There doesn't sound like that. And the reason I asked the question is, one thing I was told is in those later years when there's very low probability of reoffense, supervision can be as small as a phone call a month. And so I'm wondering how, just what we're going to have by changing that formula to really boost, or if it's all about new additional funding as opposed to moved funding.
Mr. Pelk.
Mr. Chairman and Senator Christensen, it's a great question, and I think that two different ways of for point one, I mentioned 2 points. Point one is that the two different ways of measuring supervision. The first is quantity of interactions and quality of interaction. And someone who is even at lower supervision level still is on a caseload and still is could spring up and take up time. So the number of visits might be down, but the quality of time that could be on that person could be disproportionate. Two, it's a question of cost to the overall system. If someone remains on supervision long after, they will remain subject to the conditions that are over their heads. And if they commit a minor violation of the conditions of supervision, they could wind up being revoked and be put back into prison. So they are a liability, even if they are no longer receiving the same intensity of supervision as years 1 through 3.
Thank you.
Okay, and Representative Winters.
Thank you, Mr. Chairman. And Mr. Pelka, I appreciate this. I think I've alluded to this before, but I just wanted to find out. I haven't had any solid answer just yet on this. So as you push for the 3.5-year mark, or at least the legislation pushes for a 3.5-year mark, the 42-month mark for the limitation on parole probation, and we see a clear statistical spike at 44 months that rivals that at 36 months and goes back quite a ways. And then even below, it says the average length of term is right around 4 years. My question is, why did you settle on 42 months as opposed to 48 months when that may actually provide some common ground, some middle ground regarding the needs that the judges have explained earlier today?
Mr. Chairman and Representative Winters, I actually don't remember how that 3.5-year mark was set. I think that most of the states that have established caps on lengths of probation terms have done it according to year, 3, 4, 5 years. Those 31 states that we've cited in previous presentations involve states that have established that cap. And though I think the impetus for that cap was in the same way that your sentencing statutes have floors and ceilings or parameters. For example, in Wyoming, you can receive the statutes indicate the maximum sentence length, and the statutes also guide how the min must relate to that. Those states have established a base and a ceiling for how long the probation terms can last. It's a matter of what the states have selected and what criteria they set for that length of the probation term.
Senator Representative Winters, follow up.
Just one quick follow up. Thank you very much, Mr. Pelka. And so with those other states that you have data on, do they pretty much settle in at the 3.5-year mark, or do you find more at a different place? Is 4 years also a common number?
Mr. Chairman and Representative Winters, 5 years is the most common of all the states that have established them. A feature of states that have established caps include having a level of 3 by removing caps for particular offenses of conviction. So there is no kind of categorization. It becomes more scattered once I go below the 5 years in the states that I'm mentioning. But some features of states that have provided tiers or different levels, what they have included is perhaps a removal of a cap at all on people with sex offenses. They might have established a 3-year cap for offenses except for those involving violence or DUI or others, and those will be up to 5. So there are 2 different dimensions to look at this. The first is the information on the slide, which looks at risk of reoffense, which is the results of your validated risk assessment telling you, based on that grouping, what chances of reoffense are. The second measure is offense type, which speaks to the ways that systems are structured to provide responses based on the offense of conviction as a way of punishing the behavior. So the cap serves 2 purposes in terms of how you select it, based on when most of your recidivism occurs, and that helps you focus your supervision resources, and then using the offense information, which is not associated with risk of recidivism. It's a different measure altogether, which helps you set kind of how long the range is you want to provide for available supervision lengths. The 19 states that don't have any caps on probation and parole, they are similar to how Wyoming structures, which is that the length of the probation term may be as long as the maximum sentence length for that sentence. I think that as the science has evolved around effective criminal justice practice, greater awareness has come forward because of national analyses of when most recidivism occurs, and they've seen it really is in the first 12, 18, 2 years, and so and so. So that's kind of what's prompted the focusing of the resources to get there. Thank you.
Ms. Casella?
Thank you, Mr. Chairman, members of the committee. Thank you, Mr. Chairman, members of the committee. Jennifer Casello with the CSG Justice Center. I think it's helpful to reiterate, some of, with the data, there's little net gain past 5 years, right? So there's very little public safety risk past 5 years of supervision. When it comes to sex offenders and sex offender risk in particular, that tends to be kind of the most discussed population in terms of extending past that 5-year mark. And when you take a look at the research in regards to sex offenders, and particularly those who score high risk on sex offender specific assessments, such as the static 99R, it looks at once a person is successful for 10 years as a sex offender, the risk of recidivism is really at the same amount as a first-time offender on supervision. And so anything past that, there's kind of very little net gains in terms of public safety and cost. And so we have seen some extensions for sex offenders in terms of public safety and being able to have a little bit of extra flexibility in monitoring. But the analysis is looking at all offenses kind of total lumped together and showing kind of where the resource allocation is most beneficial.
Mr. Chairman.
Okay. Well, we had Senator Hicks. Has he still got his hand in the air?
Yeah.
Yes, he does.
Mr.
Senator Hicks.
Mr. Chairman, first to answer Representative Winters' question, because that's the motion I made, 42 months. That's where that come from. But it was based on, it's not important to look at the peaks and the valleys of the data, but the average over that period of time. And so when you look at that 36 to 48, that 3 to 4 year period, we have a 9% recidivism rate. And then you get to the 4 to 5 year period, it's a 4%. So it was saying, look, where do you make that break? But the number was tried to kind of take an average of that. But the question I have is because Senator Nethercott brought this up, and I think that all the testimony that we had from the judges alluded to it. And I think that you guys have provided some clarification. Is this issue of the type of crime, rather than setting a hard cap for whatever it is, 4, 5, 3.5, whatever that period of months is. Do you have sufficient data now that could be mined and in the next month provide us that information on the type of crime? So once we get past that 36 months, because that's kind of the breakoff. That's where we go from 9 out to the length of 10-year probation. There's really only 6% variation from 36 months to 10 months on probation. So we're talking 6% of the population. And I think this gets to all of our concerns is the public safety side of that. Do we have sufficient data that you guys have collected now to be able to identify that? Obviously, the one that keeps popping up is sex offenders. So the reason that I'm asking the question is because if we move this bill forward, I think there had been an extremely valid point made by the judges on the public safety side, and even your own data has suggested that these most likely ones, even 4 and 5 years out, are sex offenders. Do you have enough data to help us identify that? So had this bill moved forward, we can make those modifications now in committee before it would hit the full floor.
I don't, Mr. Chairman, members of the committee, I don't know that the data, I don't know if the data is rigorous enough to isolate out offenses in which type of offense was on supervision. I think it's helpful to note that, with this is looking at recidivism and return to incarceration and not necessarily what the person was returned for. So it may not necessarily be a new offense, a new violent offense, a new sex offense. It could be missing office appointments. It could be failure to comply with treatment. It could be a positive urine drug screen that aren't necessarily related to violent offending or sexual offending. So I think that's important to note with the research and the data. Thank you.
Mr. Chairman, a follow-up.
Senator.
So if we lack the data to ascertain which one of those types of offenses that we need to hone in on, I'm assuming based on your testimony that other states have looked at this already and set different levels for different types of offenses. Is that data available to readily take a look at? So that for this offense, X state has a 3-year, 4-year, 5-year probationary limit. Is that data available that you could aggregate or compile for us to consider?
Mr. Chairman, Senator Hicks, I have a bit of a late breaking update that I haven't shared with Jen yet, but when the discussion was happening concerning types of offenses and recidivism, I contacted our researcher to look at the data he had, and he does have original offensive conviction and recidivism rates over time, giving me the confidence to say that we would be able to furnish you with that information regarding the outcomes and how they might vary. And one thing he shared with me was that, reminding me that 89% of the total group of all offenses failed within 42 months. That only leaves 11%. So he took that 11% and said, what's the distribution within that cohort? and it is fairly even on his first number across property, drug, DUI, sex violent. What he said, what we do as standard operating procedure is run it with by Department of Corrections to ensure we're analyzing it correctly. I share that just to indicate that we have confidence that we can complete that analysis and share it for you.
All right, thank you.
Sorry for long-winded.
Very helpful.
Okay, Senator Nethercott, are you still in the queue? All right. Mr. Pelka, can you drive us to a good stopping point and we'll have lunch? But
yes, sir.
Please continue.
Mr. Chairman, if I may ask, should I end in like a minute or
Well, it looked to me like over on page 31 or 32, those slides, is that a break? Just find a comfortable break for you. And
yes, sir. The members of the committee, Mr. Chairman, slide 28 is a reminder of your use of the COMPASS risk assessment at sentencing groups people into categories of when of likelihood of recidivism. Your low risk, people assessed as low risk fail at 1/3 the rate of high risk. So high risk people fail triple the rate of low risk people. And for people leaving prison and entering the community, people assessed as high risk fail at double the rate of the low risk people. When you're high risk, you have more needs. You need more supervision. You need prioritization of your programming. Right now, Wyoming has a couple different options available: intensive supervision, probation, ISP, and there's a policy option reflected in House Bill 230 that involves admission into the ISP. And the reason why that policy is put forward is that your ISP is structured in a way that ensures more surveillance and monitoring. It does not, however, assure programming. People who are in ISP around Wyoming are waiting in line along with everyone else to access community substance use mental health services and other programs. You are prioritized for cognitive behavioral therapy groups, but accompanying that intensive supervision, you're not getting that assured programming. And the failure rates out of ISP are significantly higher than people on standard supervision. So a probationer who begins probation in ISP has 76% of them fail. 20% of people on probation, standard supervision, will fail. ISP is shown in the research to work with people who are high risk, high need. People who are low risk and put into ISP are more likely to get connected and be pulled deeper into the criminal justice system and to have been found as violating a condition of supervision or not meeting some other need. They are unlikely to benefit from that intensive supervision and programming because the reason they're low risk is they don't have the types of needs that ISP is best suited for. So the reason that House Bill 230 has that policy in there to prioritize your ISP admissions for people who are high risk is to make sure that that valuable resource is prioritizing people who will benefit most from that intervention. Sometimes the best thing to do with low risk people is to leave them alone and not pull them deeper. You also have the adult community correction programs on slide number 30, which is they play an integral role in your criminal justice system. They're located in Gillette, Casper, and Cheyenne. They provide about 300 beds, which are rare in your state. And they provide the ability to work, pay your restitution, earn some money, access some programming. But right now, they're not funded to deliver assured programming. They also are set up not to respond to recidivism, but rather to sort of enhance what you're already on in terms of supervision. The text at the bottom indicates that only 5% of your ACC population are people who violated supervision. So you only have 5% of your entire beds to being used for people who violate. And that's why the 90-day policy in Bill Draft 230 was created to really augment the use of your ACCs. Those are beds that are available, but they're being used for people beginning probation, beginning parole, or on inmate status for both a means of prioritizing your high-risk population and avoiding the costly use of a prison bed. Your ACCs can play a crucial role in that.
Mr. Chair. Thank you, Mr. Chairman. In the overall discussion of probation and parole, and then what you just brought to light regarding the ISPs, and we've talked about this a little again, what's the average length of time for an ISP?
I think that would be a great question, Mr. Chairman and Representative Winters, for DOC to answer. I know there's currently in some transition and pilot program for modifying their ISP program. With ISP and the research in general around ISP programs, ISP with increased surveillance alone is not effective at changing behavior. It has to involve some behavior change strategies in addition to that, whether that be inclusive of substance abuse treatment, but also primarily cognitive behavioral interventions to change criminal thinking and criminal behaviors.
May I build on that, Jen, too? The design, Mr. Chairman and Representative Winters, the design in general of ISP is a term lasting 365 days. It's divided up into 320-day levels. As you move through those levels, once you've completed them, you then transfer to standard supervision. So it's sort of in a highly intensive supervision at the beginning for as long as a year, 320-day intervals, and you move your way on to supervision. So the design of the policy option reflected in Bill Draft 230 is to begin someone on standard supervision unless they have a high risk to reoffend or if to fail on supervision, and then use ISP as a sanction. If you're not working on standard supervision, if you're violating your conditions, prison and a full revocation may not be the right response. Even going into an ACC may not be the right response. ISP may be the right response with assured programming and services to match. It's a elite, or not, I'd say high level with the highest level available for supervision. That's what I mean to share. And the reason why, should note that there was our role, Mr. Chairman, members of the committee, was to assist LSO with translating the policy ideas that we put forward as policy options in Laramie and put them into bill drafts. It was truly my fault in a statutes. I had put, I'd offered up the policy option based on what we had covered to prioritize your ACCs for high-risk people. That only was reflected in the bill draft for ISP, and that's entirely my fault for failure to know your statutes and to designate ACCs. Whether it's today or in the future, there is a similar benefit to what is expressed for ISP in terms of prioritizing for high risk to fail people for the ACCs. There are a variety of measures that can be provided to help to shift your ACC population from working with people who are beginning probation and parole terms to people who are not complying with supervision, who otherwise would go to prison. That makes sense from a recidivism perspective, because currently, according to this slide here, number 31, the only people who enter an ACC at the beginning of probation and parole and do better than people who do standard probation are your high risk to fail parolees. And so, so there are a variety of ways to change that, but it shows you an incredible opportunity you have to rely less on ACCs for people beginning terms and shift them to responding to recidivism. They can fill that need that you have to provide programming and sanctioning and supervision in the community short of a full revocation to prison. Mr. Chairman, I think it mentioned when a good time to break. I can more quickly summarize this section, or we can and allow it a break, or we can take the break and I can help you out post break.
Senator Hicks.
Real quick question on that last point that you made as far as using the ACCs as far to treat the recidivism issue. That necessarily wouldn't take a statutory change. Couldn't the Department of Corrections do this within their own infrastructure now?
Mr. Chairman, it could be contracting is a way. These are all contract centers. So yeah, I would ask the DOC to clarify whether that could happen. I can explain the rationale for the policy option. So the measures to affect your ACC population seem to be statutes, administrative rules, and how you contract with them. Statutes would help you to close or seal off the valve of people coming in at beginning probation parole terms by making it clear in the statutes. The other way so that's the advantage of doing it by statute. Contracts and rules and education wouldn't provide the certainty and also consistency statewide in identifying a priority population, sir.
Okay, go ahead and summarize it, and then we'll.
If it's okay with the committee, instead of going through the slides, I will do an overview of numbers 2 and 3, recognizing the time crunch.
I was thinking you were just going to wrap up number 1.
Okay. Thank you, sir, Mr. Chairman. And yes, number 1 is reflected in a variety of the bill drafts in front of you from 230 regarding the use of your ISP program to the policies regarding probation. And the goal through those policy options is to focus your existing resources on high risk, high need to fail people at the early part of their probation term when recidivism is the highest, and to refocus your existing community sanction resources where they will have the best impact on recidivism reduction and on avoiding use of a prison bed. So the similar themes across the policy options we've discussed so far is ways that you can maximize the impact of your existing investments, your existing supervision officers, your existing programs.
Okay.
Thank you, sir.
Let's take a break now, and thanks everybody for a good hard morning of work, and we'll reconvene at 1:15.